Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case.
Dati mihi Anglican, so he's very much like I didn't ask you to interrupt me. Oh, for Trump's sake.
Is that correct?
Alrighty, good morning. Good morning and welcome to the Court of Public Opinion. I am the Recovery Addict. I'm too tall. Already I'm too tall. There we go. I'll bring you down to my level. Happy Monday. It is great to be here. All right, there we go. We're going to start with a seated show this morning. As the music dies out, a big welcome to Jamie, first in chat today. Congratulations, Jamie. The internet is all yours. That means you have to fix it, keep it running for the rest of us. We're about to start court, but we've got some things to do this morning. We'll catch up. Don't worry. There will be plenty of breaks. We will not be behind for long. I think we're about a minute behind or something right now, maybe less. Anyway, my day started out with not a broken pipe, but a disconnected connection on a pipe and a geyser downstairs in my basement, which I fixed quickly because it's happened before, so I knew how to fix it. But then coming back up and taking off my waiter boots, which I had to wear, I proceeded to rip my toe off. Well, just the toenail, but it feels like the whole toe is missing. So that happened. So happy Monday. I was able to successfully dodge what has it's starting to appear to be the entire Lowe's Lumberyard, which is in my hallway. I'm piece by piece, I'm bringing everything they have at Lowe's Lumberyard into my hallway. I'm sure I'm going to need some of it when I eventually get around to putting the floor and the bathroom back together. But had a good weekend. How was yours? Hopefully a little better than mine. We're going to sing happy birthday to anyone who has a birthday here. The birthday form has been closed by Sharon, so hopefully you got your nominations in. There's the sound. There's the sound, meaning we have, let's see, Webby. Congratulations on their 5-month anniversary. Let me see where the sound is. There we go. Krista Johnson, WF Cook, Gia, and Kale, all celebrating their special day. We're going to sing to them first, and then we're going to start court. I will watch the thing I recorded over the weekend later, but it's funny-ish. Okay. Here's what we're going to do. You guys stand up. I'm not going to. My toe hurts. But everyone else, please stand up. What is it with you guys and your bare feet injuries? Red Pat, I was wearing boots. It was taking the boots off. They're like waders. They're big rubber boots. It was taking the boots off that I ripped my toenail off. So, yeah. Everyone else, please stand up. Take a deep breath. Shoulders back. Project your voice to the back of the room. Blend your voice with your neighbor. Warm up with me if you will. La, 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 la. There we go. All right, we are going to sing to Krista Johnson, WF Cook, Gia, and Kale. Happy birthday to you. Happy birthday to you. Happy birthday, Krista Johnson, WF Cook, Gia, and Kale. Happy birthday to you. To everyone who's celebrating their birthday today, happy birthday. Especially Krista Johnson, WF Cook, Gia, and Kale. Thank you. I realize there are a million places you could be, a million people you could have been with, but you decided to spend your birthday morning with us here. The privilege and pleasure is all ours. Hopefully we can turn some of that pleasure back to you and make your day a little more specialer. Specialer day. Best way to do that, start off your day with free pancakes at IHOP, Village Inn, Denny's, Waffle House, McDonald's, Tammy Dunlap's house, and Andy's Grill. I think I named all the places that do free pancakes. That's everybody. But happy birthday. We'll let the music play just in case we missed anyone else. I don't think we did. I think it was a thorough singing this morning. As we get set to go to court. Let's see, let's put court over here in one window. Boom, 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 boom. Turn off all this fire monitoring that we have going on. Great news on the fires. They look like they're getting swept, like cleaned up, like everything's going to be done here soon. We're almost ready to go to court. We're just waiting for, the defendant. Once we have the defendant, we'll be closer to being ready. Okay, here comes the drum solo, everyone. Big finish on the birthday song. Beautiful. It was wonderful. Thank you, everybody. Happy birthday. With that, let me see. This is what we have in court right now. I think we're just waiting for the defendant. I don't see. He's on his way. Why is that not working? Let's try this one. This one's a little better. Shaylin Guardiola says, this case happened about an hour for me. Completely forgot about it until now. Thanks. Always having great coverage. Thank you, Shaylin. This is an interesting case. Let's see. Where's my audio on 3? Why do I not have audio on 3? I have vacuum in the background. That's nice, but that's not what I'm looking for.
File, as the court just noted, a lengthy response with much law included. Procedurally, for the record,
Lengthy response with much law included. Hang on, let's see what's going on
the
here.
parties were in Davidson County on the 8th and the 9th of last week to choose a jury. Mr. Chen had been transported on January 6th to the Davidson County Jail. Jury selection began promptly on the 8th and ended in the late afternoon of the 9th. The court did inform the parties that court would be closed on January the 10th due to inclement weather. Friday, January the 10th, all parties, including Mr. Chen, were back in Hamilton County. And at approximately 2:15, the state received notice from Mr. Weiss, the defendant's attorney, that they were giving notice to the state that they intended to introduce expert testimony regarding the defendant's mental condition, presumably at the time of the offense in 2022. Of course, this caused concern for the state for many reasons, primarily the timeliness and the violation of Rule 12.2b in terms of notice of a defendant's mental condition. The state asked for a phone conversation with all parties on Friday based on that concern and, quite frankly, just confusion, as this had not ever come up in any type of hearing or discovery or meeting with the parties it is significant to note that Mr. Moyle and I, General Moyle and I, have met with Ms. Morris and Mr. Weiss multiple times throughout the last several months to exchange even undiscoverable evidence. The state has gone out of its way to provide demonstrable exhibits, PowerPoints. We allowed them to look through our own box account. We've had several, met them at the police department to review evidence. Never has an expert witness been mentioned, and the defendant's notice did not provide any information as to what mental condition was being alleged or asserted by their expert. The court then ordered informally on that phone call that the defendant basically turn over what was in their possession in regards to the mental condition and any information about the expert. Mind you, the name of the expert was not listed in the notice that was filed at 2:15 on a snow day. And on Friday, later in the day, Mr. Weiss did send a email to General Moyle and I with the expert's name and his curriculum vitae. And I believe in that email it was also notice. It was a letter that signified that while the expert was not licensed as a psychologist in the state of Tennessee, he had received temporary licensing for January the 7th, 2025. That letter was written by the state of Tennessee 2024. It was not until approximately 5:30 on Saturday that the state received what is entitled memorandum pertaining to expert testimony.
Selena also.
In that memorandum, the psychologist kindly explains and articulates the law to this criminal court.
That's a Tennessee law.
Of which 4 attorneys involved in this case and a criminal court judge are acutely aware. And there's one paragraph in that expert.
There's a bit of snark in here.
That alleged expert's report that has to do with Jason Chen. There is one sentence in that report that states that Mr. Chen was not able that Mr. Chen was unlikely to have possessed the requisite premeditation for the act of criminal homicide. The memorandum never mentions a mental condition. As it stands right this second, the day of trial, the state has no idea what mental condition the defendant is alleging he had on November 23rd, 2022. We don't know if it's an intellectual disability based on the tests that were apparently administered to the defendant, which are attached to the expert's memorandum. Based on those, it would indicate it was some type of intellectual disability, as those are psychological examinations that go to reasoning and critical thinking. We have no idea if it's a mental health disorder such as
Jen,
schizophrenia,
thank you very much as well.
bipolar.
Congratulations on 8 months.
We had heard on the phone call with Your Honor the words voluntary intoxication, the word intoxication, the word substance abuse, the word addiction is never in the alleged expert's memorandum. This is the epitome of unfairness, Judge. The state has the right to present rebuttal proof. It's one of the reasons why Rule 12.2 has a timing subsection to it.
Voluntary intoxication is not
there
a defense
is no way
to criminal prosecution.
It is not virtually impossible. It is absolutely impossible.
Rare circumstances
that
in
the
Tennessee.
state ever could have searched for or investigated any type of rebuttal proof for an expert that we not only knew, well, we didn't know of, but we still, as of 9:30 on January 13th, have no idea what the expert is going to allege or opine at trial. We were not able to voir dire jurors on whatever mental condition this expert is going to allege existed on November 23rd, 2022. In fact, if the jury was sitting in the box right now for voir dire, we would have no idea what to voir dire the jury on.
I think they're going for the one case where it is allowed.
To a fair voir dire. We would have, in fact, asked questions that pertained to some mental disorder, mental condition, mental health issue. I have no idea. Intellectual disability. No clue. We would have, in fact, voir dired on that issue. It would have changed the process of voir dire for us. It would have changed the preparation for trial for the state of Tennessee.
Lee, thank you very much. 23 months.
Had we known that there was any type of expert witness that has to do with psychology or the defendant's mental condition, we would have an expert witness sitting in the audience right now to hear what this expert has to say if the court allows the expert to testify this morning in any type of deposition or hearing. We would have them here. We weren't able to do that for obvious reasons.
For obvious reasons.
The expert's
we need
name
their face on this.
at the end of the day on Friday the 10th. Saturday and Sunday are not working business days. While the state of Tennessee worked all weekend, a psychologist or psychiatrist in Chattanooga, we couldn't get a hold of them. And while no party in this courthouse should ever underestimate the capabilities of the state of Tennessee, we are not magicians. We can't just come up with a rebuttal expert witness on a mental condition that we are unaware of at 9:30 on January the 13th. This notice was untimely.
Yeah, I'm trying to sync
This
this up.
notice never would have been able to happen in any other case in your Honor's court except for a sequestered case done in the manner in which it was done in this case. Your Honor knows, typically, in all of the trials that the court has not only had as a criminal court trial judge, but also as a prosecutor and defense attorney, normally we move straight from jury selection into the state's case in chief. Typically, this would never have even been able to happen, much less allowed. It is in a rare circumstance that Mr. Weiss could have planned to know of an expert in early December.
What's happening here
We
is
know that they knew of
the
him on
defense
December 7th.
is claiming,
Because based on an email that they sent to us, it states that he confirmed his availability to meet with the defendant on December 7th.
we have not even had opening statements yet.
1 month before he met with the defendant in the Davidson County Jail. They waited.
She's trying to get
They
this
knew the week
defense thrown
before
out.
jury selection that he was going to interview the defendant in the Davidson County Jail. They knew that he had interviewed the defendant in the Davidson County Jail on the 7th. They were in court with Your Honor on the 8th and the 9th. The court repeatedly asked the parties, is there anything that needs to be taken up? Repeatedly. At the end of the day on the 9th.
Defense is going for
But it was not until 2:15
mental state
on January the
inculpability
10th,
due to intoxication.
after 2 years
Voluntary
of
intoxication.
preparation on this case, that the defense came up with a mental condition defense. And the defense has argued that it was only after the state provided a demonstrable exhibit to them that they realized that they needed an expert witness that had to do with the defendant's mental condition that affected his ability to form premeditation. Think about this, Judge. Premeditation has been an element in this case since 2022. The Hamilton County Grand Jury indicted Mr. Chen for first-degree premeditated murder. If defense attorneys believed that his mental condition at the time affected his ability to form premeditation, and they waited until January 7th to have an expert evaluate him, then we've got much bigger problems than a timeliness issue. Premeditation has been the case It has been an element in this case since 2022. And notably, Mr. Weiss represented Mr. Chen in 2022. There has been no counsel substituted. It has been Mr. Weiss since the beginning. The demonstrative exhibit that the defense has such a problem with, as the court has already seen, involves two pieces of evidence that have been in the defendant's possession for almost 2 years. A photo from Mr. Chen's apartment of carpet with blood on it, and a photo of Jasmine Pace from the medical examiner's office. The court found in the hearing on this issue that even the state could have superimposed this piece of evidence on this piece of evidence to come up with a demonstrative exhibit. How can a demonstrative exhibit that was given to the parties on December 11th, the day that it was given to the state, even though every party had both photos, but the superimposed photo was given on December the 11th, how is it that that photo affected premeditation in so much as the defense all of a sudden, near or around December 7th, contacted an expert witness? It is untimely, it is unfair, and the state of Tennessee has a right to a fair trial. And the people of the state of Tennessee have the right to a fair trial. We ask the court to exclude any expert testimony at this point in time that was presented to the court and to the state in an untimely fashion, especially that of Mr. Douglas Lewis.
If the judge allows this, it's going to delay the case. Oh, come on. We don't get the judge's audio?
Mr. Weiss's pleadings, he mentioned that the demonstrative exhibit seems to indicate that the victim might have been handcuffed in Mr. Chen's apartment. And that's one thing I think he mentioned is the problem with the demonstrative exhibit. Could you respond to that?
Sure. Your Honor, the medical examiner issued an autopsy report. The date of examination is 12/1/2022. The autopsy report was given to the parties just within a month or two. Of course, it takes the medical examiner a month or two to finalize an autopsy report. And in that autopsy report, there's a sentence that says, the injury locations are consistent with the decedent's fetal body positioning as found.
Not saying for sure that the victim's handcuffed while alive in the apartment. I heard you right. The medical examiner's report indicates that the blows might have been received also from fetal position, but not necessarily handcuffed. Is that correct?
I believe that Dr. Cogswell can opine in what position she would have been in when the injuries occurred, and then the jury can therefore, as the trier of fact, make their own conclusions as to the position of her body was only in the fetal position with those type of stab wounds because she had been handcuffed. So the trier of fact can draw their own conclusions, but furthermore, Your Honor, there was a bond hearing in this case in General Sessions Court in which Mr. Weiss represented Mr. Chen, and similar to the autopsy report, Dr. Cogswell testifies the injuries and the concentration are all on the right side. Virtually all of them can be inflicted with her in that bound position. So I believe that there is evidence in the record that would allow Dr. Cogswell to testify that she was in the fetal position. Whether or not he is going to testify that she was in fact in those handcuffs, that is for cross-examination. You can obviously cross-examine. That is part of the trial experience. So the defense did have information and evidence in discovery for years that would have indicated that she was in the fetal position. She was in that fetal position because she'd been handcuffed, and the jury, as a trier of fact, can find that.
Interesting. She is mad. And let's hear the defense's side. They sprung this on him on the weekend, on a snow day. It's like, oh, by the way, we're going with mental defense.
Rule 12.2b2 says timing. Notice described in 12.2b1 shall be filed within the time provided for filing a pretrial motion or at such later time as the court may direct. The timing to file pretrial motions has not ended. As of right now, without a jury sworn, I could file a pretrial motion right here, right now. This rule does not limit my ability to file a notice right here, right now. This court, and I say this with the utmost respect, could have ordered a scheduling order or a docketing order requiring the parties to have presented certain proofs, certain discoveries, certain evidence, certain motions at this point. The court has never ordered that. The defense is not in violation of the Tennessee Rules of Criminal Procedure, and the defense is in violation of any of the court's orders. So this is not untimely. It is timely. Secondly, Dr. Lewis was contacted about a month ago due to timing of the holidays and him getting authorized to practice psychology here in Tennessee. He was not able to evaluate Jason until January the 7th in Nashville. We weren't able to speak to him about his results. He had to review his results, go over everything, and we didn't get those results until late on January the 8th. As soon as we had those results and we knew that we were going to call him as a witness, that's when we filed the motion on the 9th. And even though the courts were closed, it was obvious that all the parties were aware of it. The General Wamp texted, all the attorneys texted the court. We had a conversation about it. And the court has ordered that Dr. Lewis submit a memorandum or report, which he did on Saturday. And I don't know what document the state is reading, but the memorandum in the submitted by Dr. Lewis talks about the psychological issue. Diminished capacity. It's right there. We're not alleging that Jason was insane. The state did request a notice for the insanity defense. We're not pleading insanity, so that has no bearing here. We're not saying that he has some type of mental condition. He's not has any type of mental health condition other than what's stated in here. So it is very clear the state has exact notice of what's being alleged by Dr. Lewis. And even if they don't, Dr. Lewis has been ordered to be deposed this morning. He is ready and waiting in the virtual waiting room for the court to admit his testimony. And finally, I find it rich that the state says this is untimely. This court, again, didn't file a scheduling order. That means Rule 16 discovery applies up until the day of. I was given a video from Walgreens that I had never seen before. And when did I receive this video from the state? January the 9th. I'm sorry, January the 8th. The state has provided discovery, monumental amount of important discovery in the last 45 days.
This one.
At no point did this defense seek a continuance for providing this discovery. The state hasn't sought, or the defense hasn't sought to exclude the discovery based on Rule 16 violations because there isn't one. There isn't a court order. It really wasn't until the defense met with the state and we saw the theme and theory of their case.
In front of the Walmart.
There it is.
The state is asking you to read between the lines of an autopsy report. But General Moyle said at the last hearing, and in his own response to this notice, that they are going to allege that Jasmine was shackled while alive and then killed. That is nowhere contained in any discovery, any evidence. We are surprised we are being ambushed with this same information. And once it came to the realization that they're providing this information to prove their theme, well, then it became necessary to show that Jason doesn't have or has a condition that would prevent it or negated premeditation. And that's what Dr. Lewis's testimony is all about. There is nothing preventing him from testifying at trial. The state is not prejudiced. They'll have full opportunity to depose him. They'll have a full opportunity to voir dire him during trial, and they'll have a full opportunity to cross-examine him during the course of the trial.
She doesn't like
it's
it.
not unfair.
It's a late disclosure.
And we ask that the court deny their motion to exclude Dr. Lewis. Of course, Judge.
Start with easy. The Walgreens video that you provided recently, in any way unfairly prejudicial to your case to the degree that you're asking for continuance?
No.
While, and I don't like filing schedule order, I know when I was practicing that a lot of work does get done as it builds up to trial, and so therefore a lot of things have to happen. As long as everyone communicates, I've never had it be a problem. I don't even know if it's a problem today. We're certainly discussing it. But while 12.2, as everyone knows, doesn't necessarily put a specific timeline on it except before trial. This is something that apparently the advisory committee's looked at a lot. In the notes, in the case law, it repeatedly refers to unfair surprise.
Yes.
But the state is unfairly surprised. So apparently it's a common practice or common occurrence, I should say, that a lot of times these experts are brought up at the last part of the trial prep. And so that's why there's a lot of case law. And so in this particular case, I'm clear when you asked for funds for the expert in December, it was a wise move. It's kind of an expert can help you out with helping through cross-examination or just looking at the case and helping at different angles for sure. It seems like it got rushed at some point, and it's almost like when the state allowed or was allowed to use the demonstrative exhibit, that solidified or caused you to need the service that this expert has provided you so far. There's thinking your own motion kind of encapsulates it. We could talk about it once the defense attorney, as a defense attorney, you promptly secured an expert who issued court. The length for that is the state discloses the last minute evidence for premeditation less than a month before, despite the case being for 2 years. Upon receiving this late disclosure, the defendant promptly secured an expert who issued court. So that's how I'm interpreting that. Is the acceleration came from the hearings in December where we talked about the exhibits and the one that was deemed to be admissible. Is that a fair assessment?
Yes, sir.
Okay. Thank you.
Your Honor, may I briefly respond to some of that timeline? The defense states that it was only once they learned the theme and theory of the state's theme and theory that they realized that the state was going to allege that she was shackled at the time the injuries occurred. But that timeline actually doesn't work in terms of the timeline of their expert witness, because the meeting that we had with them in which we discussed and went over the demonstrative exhibit was December 13th. The day that they got that demonstrative exhibit was December 11th. Based on email communication and the representation of defense counsel, they confirmed Dr. Lewis's availability on December 7th.
Can I respond to that briefly? Just make sure.
Yes, Your Honor. Yes, Your Honor.
There are many reasons to retain an expert, and Mr. Wise approached me on it. I wasn't sure exactly how this expert could be used. It might be just for consultation, it might be for sitting in the courtroom for cross-examination. And so I don't really hold that against Mr. Weiss as far as retaining an expert. At seems that the purpose for which this expert being offered now seems to be accelerated with the demonstrative exhibit issue. That's not my interpretation, but you want to respond to that?
Well, that goes against what the defense just represented on the record, though, Your Honor. They're saying that this expert became significant after they saw the demonstrative exhibit and also realized the theme and theory of the state, which, by the way, they are not entitled to, which shows how transparent the state has been. That the defense is not entitled to our theme or theory until opening statement, of course. But in Mr. Weiss's motion, he states this assertion necessitated the defense's consultation with an expert witness to address and analyze the state's claims concerning the photographs reportedly depicted. That's not true. The expert confirmed his availability to meet with the defendant on December 7th. The timeline doesn't make sense. Another note, Your Honor, the court was on the phone on Friday. The court asked Mr. Weiss if he could describe the mental condition just so that the parties could know. He says voluntary intoxication. This morning it's diminished capacity, which is not a mental condition, it's a legal conclusion. So he actually put us on notice of voluntary intoxication, which is not the mental condition. Again, unfairness. The state is now more confused. Diminished capacity because he was intoxicated, well, that's voluntary intoxication, which is not mentioned in the expert's memorandum. Again, more confusion. And let me add, Your Honor, it's not just that the state will need to, over the next 2 weeks, while General Moyle and I are proving Mr. Chen guilty to a jury of 12, it's not just that we need to secure a rebuttal expert, but we also have to subpoena records. We would be interested in all types of records of the defendant if he's claiming diminished capacity on November 23rd, 2022. We're going to be interested in new witnesses. Witnesses that maybe he was communicating with. Witnesses that may know about his capacity on or around November 23rd. This requires the state to do more. And General Moyle and I don't have time. That's the point of Rule 12.2 and every other rule that requires timely notice, Judge. That is the point. Any questions, Judge?
One thing you come to mind I wanted to ask about earlier on the expert report itself.
Wonder if we're going to keep this date. I know we've got a sequestered jury. That's got to be a big issue. They've been transferred down to this area and housed for this trial.
Reasonable degree of psychological certainty that it's highly unlikely that Mr. Chen possessed the requisite premeditation to the act of criminal homicide. I assume that that is the central aspect of his testimony. He'd be able to elaborate on that, but it would be that.
Yes, sir.
Okay. So, my question is that it says highly unlikely, which introduces an amount of speculation about this particular. It's not inclusive. I'm not saying the state has to agree to it, but it seems that highly unlikely is subjective, that is cutting to the Daniel factors. I don't know whether that would be substantially helpful to try our facts, to introduce a speculative opinion that it's highly unlikely, instead of he's concluded that Mr. Chen did not possess the requisite premeditation. Could you respond to that?
Yes. I don't think that forensic psychology is not an exact science. We even give leeway to exact sciences. This court deals with BACs all the time, and BACs are 99.7% effective. It's not 100%. So there is no type of empirical way that a forensic psychologist can say with absolute certainty that this did or didn't happen, or this person or didn't have this mental condition. They can only base it on a number of factors. I would show the court that in the last part of the memorandum, you can see the testing that Dr. Lewis conducted, and that testing shows which are standardized testing, that shows the base raw scores from where he gets his opinion from. I think the question that the court asks is a very good question, but it's better directed towards Dr. Lewis.
Looking at this, if I understand, and looking at page 6, it says a single standard score, generally being indexed and produced by measure having a mean of 100. If I'm understanding this correctly, Mr. Chen scored a 94. It seems pretty close to the mean. I don't know how much that would impact his decision. Maybe it's just a test that gives everyone. The other scores, the other test, the trauma symptom inventory, looks like based upon self-report, where the person taking the test is asked how often each symptom happened in the past 6 months when Mr. Chen was incarcerated. So I'm not sure how helpful to a jury it would be to have these scores for someone who's obviously been incarcerated for a long time.
I asked Dr. Lewis, that is a very interesting set of questions, but I asked Dr. Lewis about that. I said, well, wouldn't have the evaluation been more, better, effective, more closer to the event than now? And he actually said, no, that's not the case. It gives, after time and reflection, and gives them an ability to answer, I guess, more honestly. But again, that's a better question directed towards Dr. Lewis. Thanks, sir.
Anything else from the state?
No, Your Honor.
For the court on this particular motion by the state to exclude the expert,
The judge is not mine.
reflects there was an effort by Mr. Weiss to secure an expert, I thought was Weiss. And everyone agrees that this particular expert's testimony in this report was generated from the court's ruling about allowing a demonstrative piece of evidence. And so, looking at it in that lens, we did pick a jury, and I'll start by saying this. While we're picking a jury, I know this was mentioned, but I don't see this as unethical. I don't see it as something that Mr. Weiss waited until the last minute and orchestrated this from day one. It does feel very rushed. Again, this evaluation happened on Tuesday, less than a week ago. The state points out that they did not get the voir dire on a mental condition because they didn't know. Our Friday phone conversation involved diminished capacity. Put on record, we talked about whether insanity or not, and Mr. Weiss said it wasn't insanity, so that leaves only a few things. Diminished capacity was something that was mentioned, as well as voluntary intoxication. The report doesn't mention voluntary intoxication, and again, the highly likely seems speculative to me. So I interpret all this using a greater overall analysis as it just seems very hurried, and which makes sense. It is something that the state, once they got the demonstrative evidence in, that's when we see this uptick in activity. And so I can conclude fairly that the expert's testimony was based on the defense's stated need to respond to it with this particular expert's testimony. Neither side's asking for a continuance. If this case were to be continued, it would be a huge waste of resources. But the record should reflect that I would do that. If it came down to something that truly would cause either side to not have a fair trial, I would grant a continuance in this case. I don't think that's necessary in this particular event. Again, my interpretation is that Mr. Weiss secured an expert, could be for numerous reasons. In December, when the demonstrative evidence was deemed admissible, that's when things started to coalesce around this particular direction. And so I do think that the demonstrative evidence aspect is key and foundational to why we're here today arguing about this particular expert. So the ruling from the court is that, as talked about, as discussed by defense counsel, concedes that the expert's testimony would be that it would be highly unlikely that Mr. Chen possessed direct premeditation to the act of criminal homicide. I don't see that as actually rising to the level of anything that's going to be helpful to this jury. I don't think it introduces speculation. What is highly unlikely? Perhaps he could answer that, but in contrast to the DUI experts or the engineering experts for crash reconstructions, that they have a range, but they can say clearly that it happened to where the defendant's speed was within this range. It was not less than this amount or not more than this amount. With DUI, they can speculate it's at least 0.05, but not more than 0.12. In this particular case, I don't think that the expert's testimony is concrete enough to be helpful to the jury. I don't think we need to depose him for that if that's what his opinion would be. I do think that out of an abundance of precaution, the state's not going to like this part, but out of an abundance of precaution, I'm going to modify my ruling about letting the demonstrative evidence in. The ruling is that the demonstrative evidence cannot come in as an exhibit. The state can certainly use it demonstratively if they wish, and let the jury draw the conclusion. And also about the expert in the state's Dr. Cogswell. The defense has been expressed concerns that Dr. Cogswell will provide evidence that says that this was premeditated. I don't think this would have come in, but just for clarity, General, whenever you're directing Dr. Cogswell, you cannot say, is this indicative of premeditation?
I think the jury's from
Nashville. That's something I would have been objectionable to anyway, and I'm not saying you would, but just where we are today, based on defense attorneys' assertions that the medical examiner's testimony might be unfairly utilized for him to opine that it was premeditated. Obviously, you can't ask anything like that. Okay?
Correct, Your Honor. He's a forensic pathologist, not a psychiatrist, psychologist. So I think that's not still his expertise.
So based on those factors, let the state's motion to exclude expert testimony be granted.
Excluded. They granted it. They granted the state's motion. The expert's not coming in.
Yes, sir. Next time I would request to do a proffer and have Dr. Lewis answer some questions.
Now defense is trying to get something on the record to get a proffer, saying, yeah, we lost that one, but we'd like this on the record for appeal purposes.
At this point, I'll let you direct your witness.
So defense at the last minute, Friday night, said, hey, diminished capacity because of voluntary intoxication. It's highly likely he didn't have the capacity to form that criminal intent that's necessary when someone is charged. So they're bringing an expert in who they brought in the last minute and just barely revealed to the state. The judge basically said, no, I'm not going to allow it. But I'm also not going to allow the exhibit in that you said made this expert necessary. So the state got their hands slapped a little bit. They came with a late exhibit. And it has to do with the idea that the victim was handcuffed at the time she was stabbed, like a demonstrative aid that might show something to that effect. So I don't know exactly the reasoning behind this. Obviously, we're just seeing the legal battle over it. But we'll hear a little bit. We have not yet had the opening statements. So this is all pre-trial. Jury has not been sworn in yet. They're here. They're from out of town. They're being sequestered, which means they live here now. This is a trial expected to last about 10 days.
sometimes, and not others, have some connectivity difficulties. Felix, can you text Sean Johnson? Maybe have a workaround between now and when he gets here, but like a month later.
Red Pen, congratulations on 24 months. Love that pinky courthouse. Thank you so much. Christy G, member for 13 months. Thank you very much for the kind words. Shells comes in with another 24 months as well. Love the pink courthouses that are showing up. Thank you very much. Sloth Life, member for 12 months. Love the orange courthouse, member of the jury as well. New year, new trial, new courthouse color. Best place to be with old and new friends. Thank you, Scott and Mods, for everything. Queen Olive, member for 24 months. Woo, 2 years on the new courthouse. Bug Dugger, member for 20 months. Love these anniversaries. Thanks for the kind words. Our mods are absolutely the best. And yes, you're an OG. Anyone who's been here for 20 months is an OG. Frida B, member for 21 months, another OG. Thank you very much. You guys are all amazing. Your support is incredible. It makes all this possible. And from the whole RA family, thank you very much. There's our defendant there in the middle in the suit. White shirt, black suit, wearing the glasses. Mandy, congratulations on 14. You got the orange courthouse as well.
Good morning, Dr. Lewis. Can you hear us okay?
We've got 10 days of this trial, as long as everything goes forward.
Good morning.
Raise your right hand, sir.
About 26 months.
Do you swear or affirm to tell the truth, nothing but the truth, so help you God?
Oh, he's over Zoom.
I do.
Can you let Felix know we got figured out this today?
Good morning, sir.
We said good morning, sir. The defendant's cleaned up nicely. He looks very different in, say, like his arrest photos.
Yes, I can.
Okay. Can you please state your name?
I am Dr. Douglas E. Lewis Jr.
And Dr. Lewis, what do you do for a living?
I am a forensic psychologist.
What is a forensic psychologist?
A forensic psychologist is a clinical psychologist who uses psychological principles to answer legal issues.
How long have you been doing that?
I have been in practice solo for about 5 years now.
To become a forensic psychologist, do you have to get an education?
Yes. So you have to.
Go ahead.
The jury's in the courthouse, but they're not
earn
in the
a
room.
graduate degree,
They haven't been sworn in yet.
a doctorate in psychology. And in order to do that, one must have 4 years of didactic instruction, in addition to 3,000 hours, usually minimum, in practicum experiences, which is hands-on experience under supervision. Then one must go through a match process in order to get a pre-doctoral internship, which is a year-long internship, and then you earn the doctorate. Once you earn the doctorate, you must participate in a postdoctoral experience, and that is for at least 1 year, and then you become licensed as a psychologist.
So what schooling did you receive?
So initially, I earned my bachelor's degree from the University of Virginia in mathematics, finance concentration in 2009. And then later, I earned a terminal master's degree of education in clinical mental health counseling from Lynchburg College, which is now referred to as University of Lynchburg, in 2013. And then in 2019, I graduated with a Doctor of Psychology in Clinical Psychology from the Chicago School of Professional Psychology in Washington, D.C. And then later, I completed a postdoctoral fellowship at Emory School of Medicine in the Department of Psychiatry and Law Service in 2020.
And when did you graduate with your doctorate?
I graduated in 2019 with my doctorate.
And you've been in practice now for the last 5 years?
Yes.
And what does your practice?
Approximately.
What does your practice entail?
My practice entails both civil and criminal justice cases. So I conduct competency to stand trial evaluations, criminal responsibility or mental status at the time of the offense evaluations, violence risk assessments, psychosexual evaluations, independent medical evaluations, workers' comp evaluations, personal injury evaluations, and that's for both juveniles and adults.
Have you ever worked in the prison system before?
Yes. So I began supervised work in the prisons in 2015, and then I became somewhat of the de facto clinical director within a prison in 2021. Not only did I work with housing placements in terms of their psychological status, I also provided treatment in what is considered here in Georgia high max. So those are individuals who have not only committed murder or other heinous crimes outside of the prison, but also those of which who have done the same thing within the carceral environment.
Have you ever testified in a court before?
I have.
How many times?
I would say approximately 10 times. I've testified in court.
Is it just criminal cases, or do you go criminal and civil?
It has been criminal and civil.
In the criminal cases that you have participated in, have you always represented a defendant?
No, I have not. I have been on the prosecution side before. I think the last time I was on the prosecution side was probably in 2022 or 2023.
Are you licensed in Georgia?
I am.
Are you licensed in Tennessee?
I am not licensed in Tennessee. What I got was a temporary authorization to practice psychology through the board in Tennessee.
Thank you, Dr. Lewis. I want to talk a little bit specifically more about this case involving Jason Chen. Do you remember when my...
Or was recognized as an expert? Would you like to be recognized as an expert?
Oh, yes, sir.
Would you like to?
The defense moves to proffer Dr. Douglas E. Lewis as an expert in forensic psychology.
State one of audience witness.
Your Honor, this is, as a proffer, the state doesn't have a right to cross-examination. So if this is just simply a proffer...
I'm proceeding if you want to even have him qualified as an expert.
Sure. The state would like to log your...
Yeah, she's like, let me fire some questions at him. Okay, so this is an expert the defense wanted to bring in. It's been ruled he can't come in. The defense is doing this proffer for the
Dr.
appeal.
Lewis, you said that
The jury will not hear this.
Got your doctor of psychology in 2019, is that correct?
That is correct.
But you were not licensed as a psychologist until 2021, is that correct?
That is incorrect. I was licensed in August 2020.
Okay, August 2020. And then in Virginia, it was August of 2021, is that correct?
That is correct.
All right, so licensed as a psychologist, and your degrees in clinical psychology, which is different than forensic psychology, correct?
It is the generalist form, but forensic psychology is a specialty. One must be a clinical psychologist in order to be a forensic psychologist.
So I'm sorry. Did you get a degree in forensic psychology or clinical psychology?
No such degree exists. You cannot get a doctorate in forensic psychology and practice as a forensic psychologist. You must be a clinical psychologist first, and then you must specialize in forensic psychology.
I understand. Okay. And you stated that the Chicago School of Professional Psychology is in Washington, D.C. Is that correct?
Yes, I was at the Washington, D.C. campus.
There was a short
went
relationship
to
involved.
School physically in Washington, D.C.?
No, I did not. So essentially what happened was I earned my degree, or I matriculated at the Georgia School of Professional Psychology in Atlanta, Georgia. While I was on pre-doctoral internship at the Superior Court of District of Columbia, unfortunately, the school abruptly closed while I was on pre-doctoral internship. And so what happened was the American Psychological
School shut down
Association,
while he was going.
in addition to the Department of Education, moved those of us who were affected by the school's abrupt closure to the Chicago School of Professional Psychology in Washington, D.C.
School
So
went
essentially,
bankrupt.
it was somewhat of a pro forma or formality in terms of a teach-out agreement that was reached by the Department of Education and the American Psychological Association in 2019.
You went to online school?
No, sir. Excuse me. No, ma'am. You cannot go to online school and graduate and get a license in Georgia. You must go in person. I went in person for 4 years to get my didactic instruction, and then I matched to my first choice at the Superior Court of the District of Columbia.
But on your resume, it states from 2015 to 2019, you were a psychometrist in Atlanta, Georgia.
I went to school in Atlanta, Georgia, ma'am.
But your resume says that you went to the Chicago School of Professional Psychology in Washington, D.C.
Okay, so let me explain again.
I'm sorry, I'm confused. Yeah, I'm very confused.
I know, I want to help you if you allow me to, ma'am. So I matriculated at the Georgia School of Professional Psychology, which was located in Atlanta, Georgia. While going to school in person, because I come from humble beginnings, I also had to work. So I worked as a psychometrist alongside with getting my doctorate from the Georgia School of Professional Psychology.
We're spending so much time on this guy who's not going to be in the case.
You must go to school for 4 years and receive didactic instruction and practical experiences. Then you must match at an APA or American Psychological Association accredited internship. I matched at my first choice, which was the Superior Court of the District of Columbia. While I was on pre-doctoral internship, which is a year-long working supervised experience, my school, the Georgia School of Professional Psychology, abruptly closed around March the 8th of 2019.
That sounds like
the
a
Department
tax
of
problem.
Education and the American Psychological Association, understanding that we were about to graduate and the school closed, did what is called a teach-out agreement. The teach-out agreement was with the Chicago School of Professional Psychology, the Washington, D.C. campus. And that is where I graduated from.
Okay. Your resume states that you are an adjunct assistant professor at Emory University. So the year that you received your licensing, you also became an adjunct assistant professor at Emory?
Yes.
And your LinkedIn says that you've been an adjunct assistant professor from September 2021 into present. So which one is correct?
Not the LinkedIn.
What is correct is what's on my CV. So what happened was I graduated from the postdoctoral fellowship program in 2020. As soon as I graduated, because of my work, they wanted me to stay on to teach others. And so 2020 would be the correct date.
So September 2021 on your LinkedIn is not accurate.
If it says September 2021 on my LinkedIn, it must not be accurate. Let's go with my CV, please. That is the most up-to-date and accurate.
Update your LinkedIn, sir.
And a lot of your work has been with inmates, correct?
That is correct.
And a majority of your work has involved a defendant's competency to stand trial. Is that correct?
I wouldn't say it's the majority of my work, no. I've done a lot of work with competency to stand trial, and I also was integral in developing a jail-based competency restoration program, and I've also published on competency restoration. But I wouldn't say it's the majority of my work, no.
What is the majority of your work?
The majority of my work just includes the specialty of forensic psychology. So I do civil and criminal work, and it really just depends.
It just depends. Great answer.
What is the majority of your work?
I wouldn't ascribe anything as being the majority other than the work of forensic psychology. So forensic psychology includes both civil and criminal work, and that is the majority of my work. It's not a particular type of evaluation or type of activity that I would say would be the majority.
Okay.
The specialty is the majority, ma'am.
Okay, and you testified that you have testified approximately 10 times in both criminal and civil court?
In totality.
10 times. And how many of those times were in criminal court or in a criminal case?
I really don't recall. I would say the majority of them were criminal. I think only 2 of them involved civil, and that was parental fitness / custody type evaluation. So I would say it was definitely the majority criminal. I probably prepared over 100 reports for the court, and so I would say the majority would likely be criminal.
Okay, so 8 criminal cases. Of those 8, how many involved a homicide?
1.
Okay, and what did your testimony involve in that case?
I don't know if I can get into the specifics of that, but what I will say is that I was retained by the defense on that case.
Was your testimony regarding the defendant's competency to stand trial?
Oh, no. My testimony was regarding mitigation for sentencing.
So you testified at a sentencing hearing?
Yes.
And you understand that there's a difference between testifying and being tendered as an expert witness and qualified by a court as an expert witness, correct?
Got him.
In the state of Virginia, where I testified for this particular case, I was voir dire.
How many times have you been qualified by a court as an expert witness?
I would say approximately 10 times.
Where?
Each time that I testified, I had to be voir dire by both sides.
I'm not asking about voir dire. I'm asking about tendered and qualified as an expert witness in a case. Qualified as an expert witness.
If I'm understanding it correctly, approximately 10 times.
Wow. I like this guy.
You testified that
I like her too.
You often do evaluations on mental state at the time of the offense.
Yeah. So it's called different things based on the state. So in Georgia, it would be called criminal responsibility. In Virginia, it would be called an insanity evaluation. So I just generally said, but both of them are the same in that it is assessing or evaluating one's mental status at the time of the offense.
You believe that insanity is the same as mental culpability?
No, I don't think I said that, ma'am. What I was saying is that the statute is named differently based on the state. So some would call them mental status at the time of the offense. Georgia, for example, calls it criminal responsibility, and Virginia would call it insanity. But it's state dependent, and the state determines what the legal standing is for that.
Okay. On your resume, there's a section entitled Adult-Clinical, and it states that in 2011 and 2012 you were, it doesn't say what the what your position was. It just says adult psychiatry / co-occurring disorders inpatient at Virginia Baptist Hospital.
That is correct.
But in 2011 and 2012, the only degree that you had was in mathematics.
That is correct.
Virginia Baptist Hospital was allowing you to work in a psychiatry
Capacity.
department with a mathematics degree?
Yes, ma'am. So in Virginia, there is a title called Qualified Mental Health Professional, or QMHP. And as long as you have a bachelor's degree and you take the continuing education, they will give you a certification called a Qualified Mental Health Professional. And so that's what I became.
Go to Virginia, folks.
And that's how I was able to work at Virginia Baptist. I also interned at Virginia Baptist under the supervision of a clinical psychologist while I was earning my terminal master's degree in clinical mental health counseling from what is now called the University of Lynchburg.
Virginia just lets anybody practice. That is crazy. What's amazing about this is the prosecutor was not even planning to even question this guy.
Psychometrist.
A psychometrist is essentially an individual who has at least a master's degree, who has been trained to conduct psychological assessments, or which involves administration, interpreting, and scoring, and that individual must be supervised by a psychologist.
And your resume states that you were a psychometrist from 2015 to 2019, is that correct?
Yes.
And this is while you were...
that role.
What?
In that role from 2018 to 2019, I took on I was a reviewing psychometrist, which is a little bit different from actually administering the scores or administering the measures. So from 2015 to 2018, I was in person actually administering the psychological test, scoring and interpreting and writing reports. From 2018 to 2019 as a psychometrist, they had me review other psychometrist reports for their accuracy and then send them to the psychologist.
I think most of us are like 3/4 of the way to getting that psychologist certification in Virginia. Congratulations, everybody.
2016 to 2018, you have two separate places in your teaching experience. It says that you were a teaching assistant with the Georgia School of Professional Psychology. What are the difference between those two? Why is that listed twice on your resume?
Because I was a teaching assistant for multiple professors at my graduate program.
And you were also a psychometrist at that time?
Yes, ma'am.
You were also working in Beaufort, Georgia in that time?
That was as an intern, but yes, ma'am.
And you were also in College Park?
Yes, ma'am.
Busy guy. It's crazy what we do to get through school, though. More power to him.
Let's turn towards this case. What were you asked to do in the case of State versus Jason Chen?
I was asked to assess or evaluate the issue of premeditation.
When were you asked to do that?
December the 10th is when I was asked to do that, of 2024.
When was your first communication with defense counsel in this case?
It was late evening, December 7th of 2024.
And you said that you were asked about premeditation. What does that mean?
Premeditation as defined by the state of Tennessee.
As it relates to Jason Chen?
Yes.
What is the offense date in this case?
I don't recall the exact offense date. I do recall that it was in 2022.
Okay.
I believe it was November of 2022.
And were you asked to evaluate the defendant for mental condition?
Yes, I suppose that was a part of it, yes.
What were the other parts of it?
Well, the only thing that I was asked was about the issue of premeditation. But of course, if I'm conducting a psychological evaluation, there is a possibility that a mental condition could emerge or be revealed. But my understanding, my understanding was that that individual had never had any mental condition. But part of a psychological evaluation, such could be revealed.
Did you decide that Mr. Chen has a mental condition?
I did not give Mr. Chen a formal diagnosis. However, Mr. Chen does have some, what I would call some mental health or psychiatric challenges, to include depression and anxiety.
Dr. Lewis, I'm sorry to interrupt. The technical transmission of what you said a moment ago didn't completely come through. I think I understand what you said, to make sure you say you did not give him a formal diagnosis.
That is correct. So I did not give Mr. Chen a formal diagnosis. However, I do know that he has some psychiatric or mental health challenges.
How do you know that?
Depression and anxiety. Based on psychological testing, based on my interview with him, and my observations of him.
When you say psychological testing, are you referring to the tests that are mentioned at the end of your memorandum?
Yes, ma'am.
Okay.
Somebody's phone's ringing.
And are you aware of how long Mr. Chen's been in the Hamilton County Jail?
Approximately, since his arrest, I would say approximately 2.5 years.
And are you able to opine as to when he developed his depression and anxiety?
My opinion is that he developed it during childhood.
So I'm assuming that you had reviewed his medical records from childhood forward?
I reviewed what was in the discovery, and in the discovery, I did not see any medical records.
I'm assuming that you interviewed his parents to learn more about his childhood.
I reviewed the statements that were in the discovery from his parent, particularly his mother. But other than that, no, I did not interview his parents.
The statements from his mother that included that he did not have a mental condition?
Yes. I saw that in the discovery, multiple times individuals indicated that he did not have a mental condition. I disagree.
Because Jason told you that he did?
No, he actually did not. He said he doesn't have any problems either.
I like a good court
battle. You had no medical records. You did not interview his mother and father when it comes to childhood issues. The defendant denies having any kind of mental condition. What did you rely on?
I relied on my years of experience since 2010 of working in the mental health field across jurisdictions. I also relied upon my review of the discovery, all the documentation that was in there. I relied upon my interview with Mr. Chen, which involved many questions, to include questions that are diagnostic, questions that deal with violence risk, questions that are about his sexual history. I also relied upon objective, tested, psychological testing that is peer reviewed, and all the other things that were in discovery. And that is what I relied upon, which is best practices in terms of the field of forensic psychology. It was a multi-method approach.
You've only spent 3.5 hours with Mr. Chen.
Approximately 3.75 hours,
Oh,
yes.
I apologize. You've only spent 3.75 hours with Mr. Chen in Mr. Chen's entire life.
That is correct.
And that was last week.
January the 2nd.
And you administered 3 tests during that 3.75 hours?
Yes, and that took him about 50 minutes or so to do, the 3 tests.
50 minutes. He did 3 tests in 50 minutes?
Yes, one of them you have to finish within 16 minutes for it because it cuts off on you. So one of them was time.
So, and then the rest of the 3 hours, you just simply asked him questions about his mental condition that he doesn't have?
No. I asked him questions basically about his life from birth to present. So those questions are across the board. Some of which of the questions you don't really know, or the individual or the examinee really doesn't know why I'm asking the questions that I'm asking.
Tell me about
They
your
appear
birth.
they're not face valid. So the questioning is not just about a mental condition.
You base your opinion that it's highly unlikely that Mr. Chen could form premeditation in 2022 based on 3.75 hours with Mr. Chen. 50 minutes of those were consisted of him taking 3 tests to help you decide this issue.
And also over 14 years of experience of working with justice-involved persons.
And one of those cases in 14 years involved a homicide.
No, many of them did. Only one of them I testified for, but I've done many murder cases that I've written for. Usually the court stipulates to my reports. So I don't testify a lot.
Well, but your reports don't have to do with premeditation at the time of the offense.
But they have to do with murder, which is what you asked, I thought.
Okay. None of your reports have had to do with premeditation at the time of an offense.
No.
And in your memorandum to the court, did you mention depression or anxiety?
I don't believe that I did say that. I don't believe I said that explicitly. However, if you look at the end where the tables for the testing, even a layperson can see that some of the scales are elevated regarding depression and anxiety. But no, I don't think I explicitly indicated that in the memorandum.
Have you ever been in jail, Dr. Lewis?
As a professional, yes, I've been in many jails and prisons.
Of the people that you've worked with, how many of them experience depression and anxiety?
Probably most of them.
You stated in your memorandum that you relied on a handful of articles or websites, in one case a book, to form your conclusion in the case of Jason Chen. Is that correct?
Relied on is probably not the right language. I would say that those items, in addition to all the other methods, is how I form my opinion. So essentially, I provided those for individuals who are not versed in mental health or forensic psychology, etc. But yes, those were a part of forming my opinion because it gives foundation of knowledge for those who are not privy or not scholar in this area.
Sure, your report says and a review of pertinent research, and then it cites to footnotes 5 through 15. Is that correct?
That's right, ma'am.
And number 5, the title is Proactive and Reactive Aggression, a Developmental Perspective. Are you going to opine about Mr. Chen's aggressive behavior?
On his website.
I intend to educate the court about some people call it in literature proactive and reactive aggression, and then in some literature it's called affective and predatory aggression or violence. And so what I want to do is educate the court about the difference between affective or reactive aggression versus predatory or proactive aggression.
And what does that have to do with Mr. Chen's mental state on November 23rd, 2022?
Well, what that has to do with it is that in terms of premeditation, typically one shows that they have predatory or proactive violence or aggression. And there are certain items that must be there, or factors or traits that must be there for such. And when in issues that are raised about premeditation where someone's arguing that an individual doesn't have premeditation, then one would look at affective or reactive aggression, because those have certain elements or traits. And so what I would like to do is, what I intend to do is to educate the court on the differences of the two.
You understand in this case you would not be testifying to the court, right?
We're not testifying to the court. I'm saying educating the court about the difference, because the differences of those two items goes into my opinion about the issue of premeditation.
How do those issues relate to diminished capacity?
They don't relate to diminished capacity.
But that's what your finding is from Mr. Chen.
I didn't say anything about diminished capacity. I didn't use those terms. My understanding is that that is not a term that's in Tennessee, but that it is recognized in Tennessee, but I'm not using those terms. What I'm saying about Mr. Chen has to do with affective or reactive aggression, as well as the impact of substance use. However, I'm not explicitly using those terms, or that term.
So, what is your finding as to Jason Chen's mental condition on November 23rd, 2022?
My finding is that Jason Chen likely displayed affective aggression while also under the influence of substances.
And what evidence or information do you have that Mr. Chen was under any type of influence of substances on November 23rd, 2022?
In terms of evidence, the only thing that I have is that his report that he was using substances, and also by my questioning of him, many of which were not face valid at all, it appears that he has been using substance for many years.
You'd agree that using substances for many years doesn't mean that you were intoxicated on November 23rd, 2022, right?
I do agree with that. However, in my work with substance users and individuals that are just as involved, people just don't stop using substances.
You guys have got to see the photo on his website.
So you are going to testify that Mr. Chen was under the influence of a substance on November 23rd, 2022 because Mr. Chen said he was?
I'm not going to testify directly in that way.
This
what
is
I'm
from his
testifying
website.
to is that he reported that he was under the use of substances, and the psychological testing suggests that he does have issues with drugs.
So can't.
I'm not directly reporting that. I'm reporting that that's what he's reporting me of.
That is snazzy.
And based on his psychological testing, it suggests that he does have issues or challenges with drug use.
Well, you said you've gone through discovery in this case, correct?
Yeah.
When did you receive discovery in this case?
He has more style than I will ever possess
It
in my
had to
life.
have been the week of December 17th, because it wasn't until December 17th that the Tennessee board allowed me to have temporary authorization to conduct the evaluation.
So, homicide cases involve an extreme amount of evidence, correct?
Yes, they do.
And between December 17th and January 7th, would you say that you went
Can
through
you
all
insert
of the
that code?
discovery that was delivered to you by the defense attorney?
Between then and January 7th, I would say no. I went through most of it. And since that time, I have gone through all of it.
What did they deliver to you?
There were pleadings, there were mitigation documents, there were police reports, there was a medical examiner's report, there were pictures of the deceased, there were pictures of Mr. Chen and his family, there was a transcript of his bond hearing back in, I believe, back in 2022. There was a lot.
And what in that discovery indicated that Mr. Chen was under the influence of a substance on November 23rd, 2022?
I don't believe anything explicitly indicated that.
Nothing. There's no problem with his website. He's just got style and he shows it.
And what was that substance?
He reported that he and the deceased drank an entire bottle of wine, and after they drank an entire bottle of wine, they smoked joints or marijuana, and then they also had wax, which is concentrated THC.
But you'd agree based on the autopsy report that there's evidence to the contrary of that, correct?
Objection to argument.
Allow it, Judge. Allow it.
I think the question was specifically to reports, or I guess the toxicology report and the medical examiner's findings. So at this point, I don't think it's argumentative.
Allowed. Yes.
You'd agree that based on the autopsy report, there's evidence to the contrary. Is that correct, Dr. Lewis?
I would agree, but I think that the question you're asking was a bit misleading, given when the body was found and given how the testing was done. Apparently, based on what I saw, it looked like the testing was stopped for some reason. And then also because there had been some time that had passed, and the way that any type of drug enters your body, there's a time where it has a half-life. So it starts to diminish or denature. So I don't think that is a clear question. I would say that yes, the medical examiner said that there was nothing found in terms of substance use, but I don't think I think that question is a bit misleading.
And Dr. Lewis, you don't have a degree in forensic pathology, do you?
I don't, but I know what I've read.
And you don't have a degree in pharmacology, do you?
I don't. However, when you are trying to be a clinical officer, you do have to take psychopharmacology. So I had to learn about pharmacokinetics in terms of medication.
And you can't, as a psychologist, prescribe medication, can you?
I cannot, the psychologists do. They do additional
Okay,
training.
well, I'm not concerned about other psychologists. You can't prescribe medication, can you, sir?
That is correct.
And your basis of knowledge pertaining to marijuana, based on your memorandum, is one of them is from the DEA website.
The DEA website is good information for laypersons, but I have treated and worked with people who have substance use disorders. So again, what was on the memorandum was for people like you and others who are not trained in working with substance use disorders or psychopathology, and that was for a reference that would be easy for you all to understand. However, I am not solely basing my opinion on the 15 citations that I gave. I'm basing my opinion on years of working with individuals in different jurisdictions who have substance use disorders and also have mental disorders.
This is going to be an incredible
But in your
trial.
memorandum, you'd agree that you referenced these specific articles as what you reviewed to help you form your conclusion in this case.
I said that those articles were useful in forming an opinion. However, they are not the only things that I use. Part of being an expert is that it's the years of working with individuals who have similar or the same types of challenges. So I would not hinge my opinion on just 15 citations. It's more so to allow the reader to understand what it is that I'm talking about. So I don't want to be misleading and have you think that only 15 citations, one of which was a DEA website, is how I came up with my opinion. It's actually my years of training and in practice with individuals.
And which of these articles have to do with a defendant's mental state at the time of an offense?
None of them.
Which you'd agree is what you would be testifying on, correct?
Yeah.
Okay, and your resume
The room is
has a
dark, so we
lengthy
can throw
list
shade.
of publications that you, along with others, have published over the years. The last publication being in 2022.
Yes, ma'am. And I think that publication was republished by the NIH, or the National Institutes of Health, in 2023.
That's great. Okay, yeah, that one was
That's
the
great.
need, the controversy, the impact of COVID-19, right?
Yes, ma'am.
Okay, and then can you point to which of these publications has to do with a defendant's mental state at the time of an offense?
None of them.
Oral presentations, you cite 21 oral presentations, several of which you would agree included yourself and other presenters, correct?
Yes, ma'am.
And which of these presentations that you gave relate to the defendant's mental state at the time of an offense?
None of them.
How many times have you testified to a defendant's mental state at the time of an offense?
Once, on the side of the prosecution.
And in that case, did you interview the defendant?
Yes.
For how long?
About an hour.
How far was that interview from the time of the offense? How long after?
I would say approximately maybe like 10 or 11 months after.
And what was your opinion in that case?
My opinion was that he was sane, or he knew what he was doing. So I was on the side of the prosecution.
So that had to do with sanity, is that correct?
Well, in the state of Georgia, it's called criminal responsibility. So I found that he was criminally responsible.
Well, you just said sane. So is it sanity or criminal responsibility?
It's criminal responsibility. The case was in Georgia.
What type of homicide was that?
It was not a homicide. It was an aggravated assault.
So you've never testified or opined regarding a defendant's ability to form premeditation in a homicide case?
I've written reports that I have opined that they were criminally responsible of a homicide. But I've never testified. But I have written reports in murder cases where I found them criminally responsible for the murder.
A report for what? I don't understand. For
Okay,
sentencing?
No. So there's two types of reports that are common in courts. One type is called competency to stand trial, and the other type is called, based on the state, it would be either criminal responsibility or insanity evaluation. Those reports, those types of evaluations are ordered more than any other type of evaluation. And so often, I would perform a competency to stand trial evaluation as well as a criminal responsibility evaluation. So these things happen pre-adjudication. They're not sentencing or mitigation.
Where do those reports go?
Okay, so the competency to stand trial evaluations typically go to the court. Now, the criminal responsibility evaluations go to the defense typically, because that's usually more of an ex parte issue. And when it comes to sanity or criminal responsibility, essentially people see it as a legal strategy at times, because it depends on how the attorney wants to work through the case. So those types of reports only go to the defense attorney typically, because the individual is admitting that they committed the crime, and I am evaluating their thoughts or actions or behaviors before the crime, during the crime, and after the crime. And for that reason, typically those reports do not go to anyone but the defense attorney, who decides how they want to work the case.
They're never intended to be introduced in a trial or in a hearing for the defendant's guilt, right?
I can't say that because I'm not an attorney. I'm not sure how they use it afterwards.
Well, where is that report in this case?
Pardon me?
Where is that report in this case?
Those type of reports are ordered by the actual judge. So if it's not ordered by the judge, then there is no report. I was retained by the defense, and when the defense or the prosecution, whoever retains me, they ask a question, and I'm the one who is evaluating the question that they're posing. But those type of reports are typically ordered by a judge.
What was the question in this case?
The question in this case was to again evaluate or assess the issue of premeditation.
That's not a question. What was the question in this case?
That was the question.
To evaluate premeditation is not a question.
Sure. Okay. Determine whether or not Mr. Chen had premeditation in this particular case. I'm not sure how you want me to word it.
Okay.
That's what I was asked to evaluate.
Okay. Let's go to the tests that you administered in the 50-minute time period you met with Mr. Chen in the Davidson County Jail. TOGRA is intended to measure reasoning and critical thinking. Is that correct?
Yes, ma'am.
And Mr. Chen, with a 94, was within the standard deviation, correct?
Yes, ma'am.
And you'd agree that school records probably also could indicate someone's level of reasoning and critical thinking. Is that right?
They could. However, there can be a little bit of politics when it comes to school records, like individual education programs or 504 plans. Sometimes individuals can be labeled or mislabeled depending on their behaviors in school. And so I would not use school records as the only standard in making an opinion.
So did you review Mr. Chen's college transcripts?
No, I did not.
Are you aware that he had scholarships to the University of Tennessee at Chattanooga?
Yes, and I actually asked how did that happen, given some of the information that I learned about his, some of his own reports about his behavior in school. I was curious about that he did earn a scholarship, but different scholarships have different requirements. So I know that scholarships that I'm aware of he likely wouldn't have been necessarily a person that would have gotten some of the scholarships I know about. However, yes, he did report the scholarships.
What does reasoning and critical thinking have to do with affective aggression?
Somebody get that guy some water.
Well, I don't think the two are directly related. However, one must have a certain level of reasoning and critical thinking ability to be responsible, knowing, or intelligent. One must have those attributes. So part of the reason why I did that testing was to get an idea of how he's functioning cognitively. And he's functioning in the average range in terms of when compared to other adults. So that's why I gave that test.
Okay. And did this test measure how he was functioning cognitively on November 23rd, 2022?
No, ma'am. However, I will say that intelligence cognitive functioning tends to be stable unless something happens like a traumatic brain injury or some type of other injury. Typically, intelligence or functioning is stable, particularly at a certain age group in the lifespan.
I understand. So if he was functioning cognitively in January of 2025, I think most likely he was functioning cognitively in November of 2022 based on what you just said.
Yes, in the absence of substances, absolutely.
We need to count the coughs.
And
how many is this so far? Is that
personality
7?
assessment inventory.
6?
Which one of these tests takes 16 minutes?
The total run.
And then how long do the other 2 tests take?
It depends. Some people have gotten it done in 20 or 25 minutes. And then some people have taken hours to do it. It just depends.
How long?
It's basically questions that says it's mostly true, slightly true, false, never. So it's things like that. So the items are short. Like some of the items might say something as short as I like airplanes. It's not much. You don't have to do much thinking. It either is or isn't. So it depends though. Often people who take a long time are people who are misleading, and they typically invalidate the test because they're thinking too much.
So in 50 minutes, you're comfortable with a criminal defendant charged with first-degree premeditated murder taking a test of general reasoning ability called TOGRA, a traumatic symptom inventory, and a personality assessment inventory?
I was with him for longer than 50 minutes.
No, that was my question.
Okay.
Are you comfortable?
Can you rephrase?
Are you comfortable with a defendant taking 3 psychological tests within a 50-minute period that you then rely on?
That was part of a multi-method approach? Yes. I would not rely just on that, no. So I think you already mentioned all the things that I did rely upon. But just the testing, no. So it's best practices that you do a multi-method approach. So I would never hinge an opinion just on testing. It's everything that I review.
For the trauma symptom inventory, TSI-2, it says that the clinical scales reflect 4 broad categories of distress: self-disturbance, post-traumatic stress, externalization, and somatization.
Somatization, yes.
Can you explain which of those has to do with the defendant's mental state at the time of an offense?
So that particular testing doesn't mark directly to a mental status at the time of the offense. What it does is it gives me a profile of how this person is social emotional function. So does this person lash out at others? Do they have anxiety? Do they have depression? Have they experienced trauma in their lives? Are they likely to become easily angered or agitated? So what that does is it's one component of gives me an idea of his personality profile, but it does not. There is not a test that loads directly onto a legal issue. That's not how testing is designed.
Okay. And so the same thing for the personality assessment inventory. That test has nothing to do with the defendant's mental state at the time of the criminal offense, does it?
Not directly, no.
Do any of these have to do with substance disorders?
Yes.
And do they have to do with a defendant's use of a substance 2 years prior to the test being given?
So typically what it does is ask innocuous questions that essentially we're recreating a personality profile. While individuals are different, there are certain challenges that people have that are very similar. So what we've developed through the testing is we are developing a personality profile panoramic of how someone is functioning. So no, it does not necessarily is not as specific as you're asking. However, when I talk about likelihood, there's a certain personality profile that is developed by use of the testing and the other sources.
Counsel, approach with us.
The judge is like, counsel, approach, please. Please approach. I've heard enough. It's like, how long you plan on going? We've got a jury back here. We drove him 3 hours. 3 hours to live in the hotel. And now you've taken half the day discussing this witness who I've already ruled is not going to be coming in. He clearly is looking at the prosecutor saying, you know, how long do you need to go? How much more do you need? What's interesting is this witness has already been ruled is not going to be admissible in trial. This expert. We're not going to get to hear him during the trial. Jury will have no idea about Dr. Lewis. But if they do win an appeal and it goes forward, all the things the doctor said on this testimony during voir dire
since you reviewed the discovery in this case, Dr. Lewis, can you describe some of the things that the defendant did after he murdered Jasmine Pace?
He visited a convenience store.
I don't know the relevancy regarding his qualifications. I don't know how that question answers. This is for here.
It seems like it could apply to both, I guess, in the sense that it's clearly relevant to his opinion. It may be relevant to his qualifications. He gives great weight to it, not much weight to it. So at this point, feel free to renew your objection otherwise at any time. It gets raised to the floor. Okay. Yes.
Okay, continue, Dr. Lewis.
He went to go purchase cleaning products.
And what else?
He also moved the victim's vehicle. He used the cleaning products to clean up his apartment.
He posted on the victim's social media page.
He left the apartment, I believe, to stay with his parents.
And what else?
I'm not sure what else you're asking me.
How much weight do you give to what a defendant does after a murder when it comes to premeditation?
When it comes to premeditation, I give it great weight. I find those details, quite frankly, to be aggravating.
What do you mean?
What I mean is that essentially, if those things, or if those actions are the actions he took, then it appears that he attempted to hide or cover up whatever act that he committed. So I take great weight to that. I found that aggravating. However, I do not find that it is suggestive of premeditation. Quite frankly, I find it to be the opposite. in terms of the individuals that I work with inside the carceral environment. If they engage in forethought or planning, they typically would not do the actions in the way that it was reported that Mr. Chen did. It doesn't fit the profile of someone who engaged in forethought and planning.
But in Tennessee, premeditation doesn't require planning, right, Dr. Lewis?
Based on what I read in terms of premeditation, it means that you have to have some type of forethought before the action is done.
That exists in an instant, right?
You'd agree that somebody who is under the influence of a substance would have, how would you say it? Well, a difficulty completing tasks that a sober person may be able to complete, correct?
They probably wouldn't be able to do it in the exact same way. But someone who's been doing substances for quite some time, they may be able to function a little bit better than someone who perhaps is just starting a substance.
So if Mr. Chen was a regular marijuana user, he probably could have functioned a lot better if he was under the influence of that substance?
He may have been able to. However, he also said that he used wax, which wax is a much greater concentration of marijuana or THC.
Do you take into consideration when forming your opinion that criminal defendants will most likely say whatever they need to say instead of going to prison for the rest of their life?
Absolutely.
How is that factored into your decision here?
I didn't give great weight to it. It is part of the decision, but I didn't give great weight to the use of the substance. I gave more weight to the personality profile type that he fits into, more so than the use of a substance. He did report that he used a substance. The testing shows that he might be a substance abuser. However, that is not something that I gave great weight to.
You did not give great weight to the use of a substance.
Great weight? No. It is a part of it. But I did not give great weight to it because, as you mentioned, he reported that he used a substance. But that's not something where I'm hinging my decision solely on substance use.
What did you give great weight to?
What I gave great weight to was the personality profile type that he fits. For example, my understanding is that
personality profile?
The one theory is that he planned, or he planned this murder because the victim was bound. So if you understand, or if you work with individuals who have a psychopathic or psychopathic personality, or who are a sociopath, you will learn that the details, as is mentioned in the theory that's been presented, is not it is not consistent with it's not consistent with the evidence. Someone who
it's not consistent with the evidence.
Would conduct an act of that sort. They build gradually. You don't just start out a murder in that type, or murdering or harming others in that type of way. That is a gradual type of violence or aggression. So what I was looking at his personality profile type, and then I also was looking at the different theories that were presented. And so what I'm saying is that we would expect to see other things within his personality profile type. There should be other violence or aggression. There should be other charges of violence and aggression. There should be a history there should be a known history of maybe intimate partner violence. There's a lot of things that should be within the personality profile type and within the evidence given the theory that's been presented, that's not there.
How many of Mr. Chen's former girlfriends did you speak with?
None.
How many of Mr.
I
Chen's friends
expected legal
did you
involvement.
speak with?
None.
How many of Mr. Chen's family members did you interview?
None. I reviewed what was written in the discovery.
So you're basing your knowledge on Mr. Chen's prior violent history on what Mr. Chen told you?
And I'm also looking at the legal record. Could you produce some charges for Mr. Chen in terms of violence and aggression? Because typically that's what those individuals like that's what they have at a much younger age. And now they start at 10, 11, or 12 years old.
Hang on just a second, Jim. You approached here.
Okay, we've got some sort of security incident, I think, because a bailiff came up and interrupted the proceedings while testimony was going on to tell the judge something. Now the judge has brought the sheriff in.
We're letting the jurors go downstairs to stretch their legs. I don't want them to walk by and hear anything. Give me just a minute to do that.
Yes, Your Honor.
We can proceed.
Yes, Your Honor.
Okay, so
Dr. Lewis, you can just hang out for just a moment. We've got to take a pause, and then we'll resume as soon as we
the
can.
jury is being moved in the courtroom, or in the courthouse, and they have to walk by. And this prosecutor, I think, has a piercing voice that might be able to be heard in the hallway. And so they don't want the jury to hear anything as they're brought by. I think they're taken downstairs for... Apparently we got a break. Not sure. Let's see what this station's saying.
And let you know a little bit about what's happening now.
Okay, so they're just working on... I guess we got a break. I'm not sure how long. Nice seal. I like the lighting that highlights the relief pattern on the seal. The shading looks great. All right, big stretch break. She has a powerful voice. She does. And the microphone system and everything else. Selena, okay, this is an important thing. I realize we want to be, hearing testimony right away as we kick things off. But this is an important step. When the defense brought this up, and they did literally Friday on a snow day, they filed this motion saying, oh, by the way, court starts on Monday, and we're bringing in an expert witness that'll say that due to voluntary intoxication, the defendant did not have the capacity to have premeditation in this event. So that was basically the testimony this witness was going to bring in. The state went through the roof. All these questions, everything she's asking here in the line of questioning, she's either doing on the fly or she prepped over the weekend from Friday night when they made this notice, when they filed this notice. Kay in South Carolina, congratulations, 24 months. You got a pink courthouse. Love being here with everyone. Thank you, Kay. I appreciate that. One of our OGs. I appreciate you all. Bite Me also gifted a membership. Thank you very much, Bite Me. Thank you, Rebecca. Marie Pierre Rollabard? Marie Pierre Robillard. Robillard. How about that? First try. Got it. Welcome to the gallery. Thank you very much, Marie. Let's see. I think that's everybody I missed. Apologize. Anyway, the judge ruled that this witness can't come in, that it's done. Nope, no go. The jury will not hear this. And he also, in the same ruling, said, and we're going to prevent the state from submitting this exhibit, demonstrative exhibit. That is what the defense said. Because of that exhibit, we need this expert. So he says, just to be sure, we're going to keep that out as well. Now, that we were okay. We could have gone forward with the trial at that point, but the defense said, well, Judge, we'd like to proffer this witness testimony. We know it's not allowed, but we'd like to proffer it, meaning we'd like to record it, document what he would have said, so that if, down the road for appeal, if this is overturned and the appellate court says, yeah, the judge was wrong in keeping this witness out, they'll have an idea of what would have come in. So it lets them sort of see into the future without going down that path. Robillard. Okay. I just saw billiard. I'm terrible at pronouncing things, and names are the worst, so I apologize. We are excited to have a trial again. We have crazy things happening. We've got one I've got to show you from over the weekend. We've got one going on in Texas with the judge, with the psychiatrist who says that he wants to counter-sue for his ankle monitor that's killing him or something with radio waves. We've got a lot of stuff that we'll have to fill in the breaks, or maybe possibly at lunch. I don't know. This is going to be a 10-day trial, according to the calendar. It might be 11 now, the way things are going. The pink looks really good on the courthouses as well. I did okay. Thank you, Marie. I'll probably never be able to say it right again, but I appreciate it. Pink courthouse on order. Let's see. Anyway, so they're putting all this down on the record. It's important for the appeal. Just goes on for the process. That's important that way. Once this state is done with their portion of the voir dire, I hate to break this to you, but once the state is done, I think defense is going to get back up and ask a bunch more questions. I get more into the meat of what he would testify and what he would say. I think we stopped right at the point where, from the defense standpoint, the questioning was done when the judge said, do you want him, ruled as an expert witness? That's as far as we got. So defense still gets another go at this, so we're not done with him. He might be our only witness today, and he's not even in the trial, which is crazy because he still gets to bill for these hours. But we'll see what happens. You guys wanted a trial? We brought you a trial. Here we go. Justice Obsessed, thank you very much. I appreciate that. I love covering events where we can bring information, valid, pertinent information, right to the people who want it and need it. Jury from Nashville is sequestered. That means that they cannot go home for 2 weeks. They can't go home on the weekends. They can't go home at night. All their meals are provided for them. They are literally isolated. Sequestered away from everybody, and they're sitting in the courtroom. I think right now they're either on a lunch break or going to lunch, but we'll see what happens. Free hotel, free HBO. Any info on why the sequestered jury? I think they needed a jury from outside the area. I don't know why they didn't just move the trial. But yeah, we don't get to see this often. I'm really excited about that. Too much local coverage locally. This witness is sequestered from the trial. Yeah. But we'll hopefully get some audio back here in just a second. Listening to some of the news channels that are covering this as well, so we'll hopefully get some more information. 1776 daughter, welcome to the gallery. Thank you very much. Thomas, a podcast partner, one of my current golf mates used to live there and ran into Chen frequently. Oh, my goodness. Wow. Maybe he'll be a witness. Ellie Veldman, member for 21 months. Thank you for the reminder to hit the like button. That does help our channel a great deal. Thanks to all those who have dropped a pin on our viewer map, just so we can see where everybody is at. Not precisely. We don't want your full address. We just want to see the general area. There's a link. The first one is where you drop your username and your general address, like city and state or province or something like that. And the second one is where you can view all the maps. We do have 745 pins on the map, and I think every state except for Alaska and Hawaii are represented so far in the United States, as well as across the UK, Scandinavia, and a fair amount of Europe, South Africa, Australia, New Zealand. Got some great people on the map here. I don't think I've seen this judge before. This is Judge Boyd Patterson. The name sounds familiar, but I don't think I've seen him before. So this case has some interesting facts. Once we actually get down into it, that we don't normally see in trials. For instance, the victim's family entering the crime scene before the police, literally breaking into the crime scene before the police. It puts a little question mark there. It puts could evidence have been planted type question mark, and that'll come up in trial. But there's some very interesting happenings as we go down the timeline of what happened. If you posted a pin or you submitted a pin, just know that they get manually reviewed. We do that before it doesn't just automatically put on the map. It gets manually reviewed so we don't get like trolls putting stuff on there that's inappropriate. And also, in case someone accidentally shared their entire address, we'll delete that out. We'll strip that out of the data so that your precise location is not given out. That does mean that if you live in Houston, which is a big city, and you post your location as Houston, it may not show up on the pin as your name, specifically when you look on the map. It might be somebody else on Houston. It only shows one pin per city, but if you go on the search field, you can search for users, and then it will show where they're at. So the map does not have all 745 pins showing because they're duplicates. What time is the guy in court today that we watched Friday? He's in right now. It's already happening. It's going on, but we're on this trial right now. We'll go back and jump to that when we get a break or later in the day. We also have a interesting one. We've also got an interesting one that happened out of Detroit with a defendant who really wants the process sped up and he wants to plead guilty. Andrea, the way to pin is just look for the link that's shared periodically by Amber right here. The first link, this top link is the one where you submit your name. Then wait for a little while. It doesn't happen promptly. The second one is where you view the pins. It's just a hearing in Detroit. It's actually interesting. It's a hearing for arson in Detroit. Let's see what happened so far on day one. This is through WTVC in Chattanooga. District Attorney Wamp argues to exclude the defense expert witness. Court hears from Dr. Douglas Lewis, forensic psychologist, to see if he can testify as an expert. Dr. Lewis believes Chen has mental health challenges like depression and anxiety, does not give formal diagnosis. Dr. Lewis's report says Chen likely showed affective aggression while under the influence of substances the night Jasmine died. And knew this in the judge and the attorneys are meeting behind closed doors right now. In chambers. That's interesting. We'll hear what happens when they come back out. All right, camera's got a wandering eye. There's our jury seats. Don't want to see too much. Bailiff. More bailiffs. That's my least favorite type of clock, just for the record. The numerals just stuck on the wall. Like the wall is the clock. Don't know who needs to know that, but that's the kind I don't like.
Just like that.
Yes, Your Honor.
Thomas, we can count on it. It's interesting. I don't know. We might get a plea. If this defense is not allowed, the judge has a standing desk. Looks like we're continuing prosecutions. We're just picking up where we left off.
Dr. Lewis, I just have a few more questions for you this morning. You had just testified that you based a majority of your opinion on Mr. Chen on his personality profile. Is that correct?
Yes, his personality profile, as well as just like any other mental status at the time of the offense type of evaluation, there's certain type of questioning that you ask the individual as they walk through various acts or allegations. So this is what I conducted is no different. Hundreds of mental status at the time of the offense evaluation that I've done in the past. So I think that from the question that you're asking, it appears that you may not have knowledge of how mental status evaluations are conducted, which would be appropriate. So, yes, I look at the personality profile, but there's also a specific type of questioning that you ask the individual.
In 3 hours?
Yes.
Okay.
And you review the evidence that's been collected, which is the discovery. So I looked at the things in the discovery as well. So testing, interviewing, and also the discovery. It is very, very typical in terms of best practices in forensic psychology.
You testified that you did not issue any formal diagnosis for Mr. Chen, is that correct?
That is correct.
But you just mentioned psychopathy and sociopathy.
Right, those are not necessarily diagnoses. Those could be personality profile types. So that's what I'm looking for. That's what I'm looking at in terms of your characterological function. So those are not diagnoses. So a diagnosis for something like that would be antisocial personality disorder. But psychopathy and sociopathy aren't a diagnosis. They are labels or they are labels that tell us something about how the person's personality profile is, but not necessarily a full diagnosis. For example, you won't find that in the DSM-5.
Ooh, the DSM-5. What is the DSM-5?
It is the book that we use that basically lists every mental disorder and their characterization of each one. So, for example, you will see something like major depressive disorder will be in the book. And there it says that this person has this, and that. And you use that manual in order to give someone a formal diagnosis.
Why did you not cite to the DSM-5 in your memorandum?
I don't believe it was necessary.
I'm
not sure how that would be necessary.
Based on your opinion, is Mr. Chen a psychopath?
No, he is not.
Based on your opinion, is Mr. Chen a sociopath?
No, he is not.
What personality profile does Mr. Chen have that caused you to come to the conclusion that it is highly unlikely that on November 23rd, 2022, he was unable to form the requisite mental state of this offense?
Just like any type of other mental status type of evaluation, I reviewed what his psychological or emotional functioning is, and what I found was there was a potential history of childhood trauma, there was depression, anxiety.
Dr. Lewis.
And you mentioned before.
I'm sorry to cut you off, Dr. Lewis. Hang on just a second, okay? Jurors are walking by. I'm sure they don't hear anything we're talking about.
The jurors are walking by. I don't want them to hear anything we're talking about. Apparently, the jurors walk right outside the courtroom. Probably one of the longest voir dires I've seen of an expert witness. You're right. Karen Reed took 2 days. But it was it a voir dire or was it a... How long did it take him to walk by? Must be admiring the courtroom artwork. Andrea, awesome. It's wonderful to get Hawaii on the map. We'll give it a minute. I think it'll update. They're using their silly block. I like to think they're all holding onto a rope, being led by a bailiff. I have a confession. I have a hard time remembering to count coughs. I'm up to 12. There's 13 now. But they just happen so frequently and it's so natural to hear them in court that I forget to count. So I might have to count something else. No! Rob printed a pickle? Was it a dill? I mean, was it a big dill? Mary Murphy, there are 2 links. There are 2 links in the message when we post it. One is where you submit your name. The other is where you
Dr.
view
Lewis,
the
you can continue with
hymns.
what you were saying about the personality profile of Mr. Chen.
So I was saying that he potentially has a history of childhood trauma. He experiences symptoms of depression and anxiety. He's younger than 25 years old. There's no known legal history that I found. That's why I asked you if you found any charges in terms of violence or intimidation. There's a history of misbehavior within the school setting. So those are all the things that I put together in terms of over the course of evaluating him. So there isn't a particular name, so to speak, of a profile. It's developing a profile of who this person or individual is. And you compare it to, as you mentioned, something like a sociopath or a psychopath, you would expect different information to be in the actual profile.
What does potential childhood trauma mean?
Well, the psychological testing revealed that there was likely a history of trauma. And then when he was inserted in his childhood, a professional like me, and perhaps others, would likely characterize some of those incidents as abuse. However, Mr. Chen did not characterize it as such.
Mr. Chen said he wasn't abused.
Correct.
But you think he was?
However, he described the incidents that he described, most professionals, and likely others we described as a form of abuse.
Well, did he describe them, or was that questions in his testing that you gave him?
During the interviewing, he told me about his childhood during the interview, so he described them.
Were there questions on the test also related to childhood trauma?
Specifically childhood trauma, no. The testing was asking about, basically what the testing does, it's not face value. So it asks questions that may appear to be innocuous to the person who's answering or to the examinee. However, based on how he responded in the testing into the interpretation suggests that likely he has experienced trauma in the past, because he matches how other people who we know for a fact have experienced trauma is how he responded. So what we do is we do comparison groups. So we're comparing how he responds to items to how others who we know are known to have certain disorders or certain life experiences.
What was that childhood trauma that he denied having, but you found that he had based on what he was saying?
The childhood trauma is not categorized as trauma.
This is where it goes too far.
Okay.
This is where it goes too far.
We can get into it later when we get into it. This witness is allowed to testify further, and he is recognized as an expert. And Mr. Josh wants to lay the foundation. You can ask him about the specifics later.
Okay, so the judge says, I'll
You'd
sustain
agree,
the objection.
Dr. Lewis, that a
can ask him
majority of
later.
people with childhood trauma don't murder other people, right?
Once he testifies. Because this is all before his testimony.
And I would never suggest that would be an excuse for any type of law breaking.
We'll get that question, and we'll get the answer. It's just not the right time right now during voir dire
Would
to see if he's an
your
expert.
opinion change if you would have spoken with former friends of Mr. Chen that would tell you that they were scared of him?
That would be speculation. I don't know if it would change or not. It would depend on the veracity of the information or the details of the events that his friends would say. So if there's information that's there, I'm more than willing to listen and to hear it. And yes, my opinion could potentially change. However, I have no way of knowing that until it happens.
Well, some experts would have interviewed people.
Absolutely, they absolutely would have. Yes, I think that is very much a common, I would say, a common practice for some. However, it is not necessary or mandatory.
He'll testify in the proffer.
particularly
haven't got
not
to the
for
proffer
mental status
yet.
at the time of the offense or mental state type of evaluation. So I do certainly agree with you that that does happen, but it's not necessary.
Why did you not come to Chattanooga to see Mr. Chen?
Because by the time I was available, he had been moved to Nashville. I didn't get clearance to even do anything until December 17th. And I was away on holiday December 16th through the 20th. And then I went out of the country from the 23rd or 24th until January the 3rd. And so I wasn't able to see him until January 7th. By that time, he was moved to Nashville, which is where I went to go see him.
Well, what about January 4th, 5th, and 6th?
Ma'am, there's no way I could have done that because I took a 24-hour flight from South Africa. So I need to rest.
He was in South Africa? 24-hour flight. Wow. I'm guessing there's some layovers in that. You can get most places in the world if you're flying within 24 hours.
We're still trying to decide whether or not we qualify as an expert. Does the state object to be qualified as an expert?
Yes, Your Honor.
State your reasons why, please.
Your Honor, Dr. Lewis has he was licensed as a psychologist in 2021, so he has several years of experience as a forensic psychologist. Okay, I apologize. In 2021 in Virginia, in 2020 in the state of Georgia. Of course, he's not licensed as a psychologist in the state of Tennessee. He, in fact, probably has expertise in some type of psychology. But having an expertise in some kind of psychology does not mean that you have an expertise in a defendant's mental state at the time of a criminal offense. A podiatrist does not have an expertise in forensic pathology, even though they're both medical doctors. So no disrespect to Dr. Lewis, but as you go through, as we did, Dr. Lewis's resume, there is hardly anything in the resume or in his memorandum that has to do with reliability or trustworthiness of his findings as it has to do with the defendant's mental state at the time of the criminal offense. There is hardly anything. There is a lot regarding a defendant's competency to stand trial. That is not what we are here on. This expert cannot testify in toxicology. He is not, and I don't think this will be contested, he is not an expert in toxicology, which is apparently a primary issue of what he would opine on is the defendant's substance use on November 23rd, 2022 that he has no facts or information on except for what Mr. Chen's told him. So he has no basis of knowledge. He is not an expert in the field of toxicology. He is not an expert in pharmacology. Sorry, Judge. Pharmacology. He is not a medical doctor. He has not presented enough facts and evidence of which he based his opinion on the defendant's mental state at the time of the offense. And in fact, Your Honor, the state is more confused after hearing his testimony because the defense alleged that the argument was diminished capacity, to which the experts adamantly denied that he was arguing diminished capacity. We now have a personality profile, childhood trauma. There's been nothing on the record that would establish that this expert should be qualified as a forensic psychologist as it relates to a defendant's mental state at the time of the offense. Moreover, he has not had enough time to speak with the defendant. He has not done his due diligence in checking the defendant's records, speaking with the defendant's family members or friends, and due to the fact that he's had the discovery since December 17th, it was on, quote, holiday and in South Africa for a majority of the time thereafter, he has not even had enough time to adequately go through discovery and make any type of finding such as this in this case. So we do object to this witness being qualified as an expert.
Wow.
I do think the bar, there's some standard obviously for letting an expert testify. I think that it's whether or not some specialized knowledge might be helpful to the finder of fact in this particular case. He seems like perhaps he hasn't had the depth of experience that other experts have testified. I don't think he has that yet. I don't think there's anything that's disqualifying as far as the weight that should be given to his opinion. That's certainly something we can talk about. But as far as again his qualifications are concerned, as far as him being able to give an opinion, we're doing all this for the record. His testimony's already been deemed to be inadmissible, but I want the record to be complete. As much information as possible about Dr. Lewis. So I will recognize this witness as an expert in forensic psychology.
Okay, so he is an expert. Now we begin with the
I just want
proffer.
to clarify for my questions. Is the court finding that there was a violation of Rules 12 or 16?
No, I'm not finding there was a violation in the sense that a deadline was missed. I do think that if you want to clarify my ruling, there are actually two aspects to it. The first is that it's clear that this expert's services for this purpose, for what we're talking about today, the defense felt it became necessary after a recent hearing last month where the monster exhibit was admitted, and there was some concerns about that, as well as the medical examiner's testimony going to premeditation. And so I think that based on the timing, so that the state is not unfairly surprised, the workaround that the court is crafting removes the major, if not the only reason that this witness's testimony on this issue was represented to this court was needed. So that's one of the reasons being excluded, is that
Defense is trying to revisit the exclusion ruling.
12.2 contemplates, as well as give the defense a fair shake, as he described in voir dire last week. So that's one of the reasons. The other is that I don't think that the opinion as written qualifies as something that would be substantially helpful to the jury. When Dr. Lewis wrote that it's highly unlikely that Mr. Chen possessed the requisite premeditation, I do find that there's a degree of speculation that is not going to rise to the level of where his opinion would be helpful. And also, I guess I can point it out now, that during Dr. Lewis's testimony moments ago, he talked about the great weight that he gave to personality profile type. I mean, it is pretty clear in case law that personality type is not something that's even relevant to a defendant's capacity to form a mental state. It's pretty well established. So there are numerous reasons that this witness's testimony has been excluded from this particular trial at this particular point. Those are the reasons. Not a 12.2 violation. Again, I don't think there's any bad faith. I think this way the circumstances unfolded. I'm not finding that the defense acted unethically in any way. It's the way that it unfolded, the short time frame. Yes, sir.
I'll need,
Actually, it looks like you got it wrong. Just kind of let him know.
So now we begin the proffer. Now defense is going to ask him some questions that the state will get some answers, and probably
I'm going to have to start from scratch.
this will probably take us at least to lunch break.
You can text Dr. Lewis and let him know that we've had some technical difficulties. I'm about to let him back in.
It's for the appeal. It's legal. It's the process we follow to preserve the record for the appeal. Trying to dial up Dr. Lewis again. The judge coming in with the, oh, and by the way, what he just testified to, saying that he used the personality profile as the basis for making this finding. Case law in Tennessee says, nope, you can't do that. Oh, he should know that. He should know that. They always hope that he doesn't get convicted, but they present. Hey, there's the judge. Present their defense and hope the jury sides with them, but they also have to preserve the record.
A moment ago, now he's not. There we go. Dr. Lewis, sorry about that. We're going slow for lots of reasons, but I'm sorry to say that sometimes technology, this court moves at the speed of technology sometimes. Well, a lot of it's user error. Hopefully we solve that for now, okay? So I believe Mr. Weiss can ask some questions now.
Hi there, Dr. Lewis. May I have your overhead?
Yes. Well,
Can he see?
I don't know if WebEx will operate with overhead at the same time. No, just either video call or the overhead.
Can I try workaround, Judge?
Yes, sir.
Unless the state's going to object, I guess it doesn't matter. Dr. Lewis, I'm forwarding what you sent to my office as a curriculum vitae. It says Douglas E. Lewis, Jr., ESYD at the top, and in the top right corner it says REB period 9.24. Is this your CV?
Yes.
For the purposes of this hearing, the defense moves to enter the CV of Dr. Lewis into evidence as Exhibit 1.
Yeah, for this hearing, not to go back to the jury. Exhibit 1.
May I approach you?
Sir, feel free to move on the court.
Is this the first CV you sent us or the second CV?
Second.
Oh, it's the updated CV.
My CV says revised 924 is the one.
That's right. Dr. Lewis, I have a letter here
This is
from
defense
Regina
now. Yep.
Lewis at the board administrator at the board of examiner in psychology. It's dated December 17th. Was this letter given to you authorizing you to practice law temporarily in Tennessee?
Practice law, Judge?
I'm sorry.
Practice psychology.
Practice forensic psychology.
To practice psychology, yes.
Defense moves to enter this as exhibit number 2.
Exhibit 2.
You can only practice law in Virginia, right? Because he's got a bachelor in mathematics.
Dr. Lewis, I'm holding in my hand a 7-page report, or memorandum rather. It says the Honorable Boyd M. Patterson, the top, dated January 11, 2025. Is this your memorandum pertaining to expert testimony regarding Jason Chen?
Based on what you described, yes.
Defense moves to make this exhibit 3.
Exhibit 3.
All right, Dr. Lewis, I want to ask you about the methodology that you used in this assessment. What validated psychological tools did you employ in your assessment of Jason Chen?
The psychological tools that are both valid and reliable are the TOBR, the TSI-2, and the PAI, broadly and well-known instruments.
Are there, if you had more time to spend with Jason, are there other tests that you would have performed?
No. I mean, certainly there are numerous tests that we have at our disposal, but I don't think that that would have been necessary. In fact, a lot of mental status at the time of the offense evaluations don't use testing at all because psychiatrists and psychologists perform. So a lot of times testing is not even used.
Are the methods that you use consistent with the guidelines recognized by professional organizations like the American Psychological Association?
Yes.
And you don't have to go through it, but are you able to cite research and case studies to support the evaluation analysis that you did on Mr. Chen's or Jason's psychological state?
Yes.
And is it relevant to premeditation?
Directly relevant to the issue of premeditation, just like most legal questions, there's nothing that's going to directly load on any type of legal issue. However, those are tools, yes, that are used to answer some of the legal questions and controversies that emerge.
Do you believe that you were provided all the relevant materials, including evidence including evidence to ensure that your assessment is objective?
That is objective, yes. I strive for objectivity, but as I mentioned earlier, with the introduction of more information or data that's objective, my opinion could change. However, based on what was available to me, as I mentioned in the memorandum, that is how I form those are the bases of how I form my opinion.
In your opinion, you say when to a reasonable degree of psychological certainty. What does that mean in the context of your opinion?
That means just like in any type of psychological science or practice, it is highly likely that what I'm saying is correct. However, when it comes to behaviors, actions, etc., we cannot say definitively anything. So that is what that means. That says that means that given the resources that I've been given, also the evaluation, the psychological test, etc., that to the highest degree to which is possible as a psychologist or a psychiatrist, this is what my opinion is. However, we can't say anything definitively.
Well, that's my question is, why can't you say this, your opinion with certainty? Absolute certainty. I am certain of my opinion. However, to say absolutely certain, I would have had to be in the room when these things were occurring, which none of us were. So I can't say this is absolutely what happened. I cannot say that because none of us can say that. However, based on the information, the data, the testing, the evaluation, it is highly likely that the opinion that I reached is the accurate one. Would you characterize your opinion as based on speculation?
No.
Why not?
Because I used and reviewed all the evidence that was in the discovery. I also conducted psychological testing. I interviewed. I reviewed his legal history, again, the things that are in the documentation. So speculation alone, based on my understanding, would be not using any form of evidence, not trying to use any type of objective psychological testing that's both valid and reliable. Those type of things, I think, I would characterize as speculation. However, when you use a multi-method approach, as I did, I would not characterize my final conclusion as speculative.
Did you make any assumptions that was unsupported by the evidence informing your conclusion?
No.
So can you explain to the court how your psychological insights from your evaluation into the mind of Jason Chen are relevant to the legal question of premeditation?
Okay, so premeditation is arguably something about one's mental status or mental state during the commission of an act. So just like any other mental status related evaluation, I am assessing and evaluating not only what came before, during, and after the act, but also I'm also looking at the personality profile of the individual. So I'm using all those things in order to answer the legal question. Typically, again, when it comes to legal questions like competency to stand trial, like mental status at the time of the offense, violence risk, etc., there is no legal question that psychologists or psychiatrists can directly answer in the way that you all are trying to characterize it. What we do is we use all the information that we have available, data, interviewing, observations, testing, etc., to answer the legal question. But it's not like A plus B equals C. That is not how these things work. Like, for example, there's no real test of premeditation. There's no test of mental status at the time of the event. We use the information that we have and the testing and the level of questioning and training that we have to make to give the court answers to its controversies.
So sticking with the premeditation, particularly in cases with premeditation or where you're dealing with intent, can you elaborate on the specific experience conducting those types of forensic evaluations?
So those type of, I actually am in the middle of one. I have one that I'm doing that has to do with the intent or the case element of intent in Virginia. And in those type of cases, we're looking at one's functioning behaviorally, socially, and intellectually or cognitively in order to make determinations about one's intent. For example, it was posed earlier about his reasoning and critical thinking. If someone, for example, has an IQ of less than 65 or less than 60, there are certain types of crimes without the assistance of another person you know that they would not be able to do because they don't have the level of forethought or thinking. In terms, that's an easy way of kind of understanding it. IQ or functioning in terms of their cognitive functioning is something where we would be able to answer that type of question.
So, can you explain your role as a forensic psychologist and how it's distinct from a psychiatrist or a general clinical psychologist in assessing premeditation or intent?
A forensic psychologist is a clinical psychologist who has specialized or specialty training in forensic psychology, meaning we have gotten some type of legal training in that we understand or know how to interpret certain statutes, and we also apply psychological principles to legal issues. For example, as I mentioned before, the idea of competency to stand trial, mental status at the time of the offense, these are legal issues. However, you need a psychologist or someone with that particular training in order to answer those questions. So we're different from, a forensic psychologist is different from a psychiatrist because a psychiatrist cannot issue testing. Usually their training in forensic is not as comprehensive as it is when you are studying to be a forensic psychologist. And we're definitely different from a general practitioner because general practitioners are there to treat and evaluate mental disorders only. They don't have the legal piece, the legal understanding. For example, I had 2 to 3 years of didactic instruction about cases that involve mental health or psychological issues.
What methods did you employ in forming your conclusion about Jason Chen's mental state at the time of the offense?
I reviewed the entire discovery that was made available to me. I interviewed Mr. Chen extensively, not just questions about his personal history, but also violence risk and also sexual violence risk. Again, those questions were not all face valid, meaning there were times where an examinee would not know why I was asking the questions that I was asking. I also administered 3 psychological tests that are both deemed valid and reliable within our field.
So, in regards to the assessments that you did on Jason,
the bailiff, they need a better messaging system.
shuffling jurors around as far as figuring out when to do that, I should say. Please continue.
Please continue. It's all about the jurors moving around.
The question is whether, right here, let me say this. Can you explain the psychological concepts of emotional regulation, impulsivity, and how they're relevant in this case?
So emotional regulation and impulsivity are important to this case because often people who commit murder or other heinous acts of violence, it tends to be in a heightened state or what I call affective aggression or violence. So someone who has trouble regulating their emotions, or someone who is quick to anger and also is impulsive, they are likely to engage in behavior without thinking. And a lot of times, our jails and our prisons are filled with people who have committed acts out of being anger, not thinking, impulsive. So emotional regulation and impulsivity are two, in my opinion, major factors in most crimes when it comes to aggression and violence.
So one of the tests you did was, is it called TOBRA? How do you pronounce it?
It's called the TOBRA.
And you conducted the TOBRA with Jason Chen?
Yeah.
How did his performance in this test inform your understanding of his cognitive capacity for planning a court?
Well, the reason why I issued that test is because someone who is highly intelligent will create a different type or may slightly change the way that we characterize in terms of the profile. Because and so I needed to know where he fell in terms of the bell curve, in terms of intelligence. So it's not a test of intelligence, but one of reasoning and critical thinking. And so if he is scored really high on there, that may have informed me in a different kind of way about how he's functioning in terms of, his proclivity perhaps for manipulation, deception, lying, etc. And so I need to know where he failed. And so I know that he falls in the average range on the bell curve in terms of, reasoning and critical thinking.
Is your opinion and conclusion based solely on that personality test?
It is based, that is a test of reasoning and critical thinking, and no, it is not based solely on that. No opinion should be formed based on one thing. It needs to be a multi-method approach.
In the TSI-2, you noted Jason had anxious arousal and intrusive experiences. How do these findings support your conclusion that Jason's actions were likely reactive and premeditated?
In terms of supporting it basically builds a profile of how he's functioning. This is someone who likely has bad memories about something that has happened to them, experiences anxiety, which is worry or restlessness. Individuals like that may be quick to agitation. They may engage in behaviors to reduce tension, like using marijuana or alcohol. This is developing a profile of how this person is functioning daily.
How does your reliance on the empirical testing, using the tests that you did, and I guess the evidence and discovery that you received, ensure that your conclusions are not speculative?
This is all for the appeal, preserving it for the appeal. It's a proffer.
Strongly ensures it because best practices indicate by the specialty guidelines of forensic psychology, which were adopted by the American Psychological Association in 2013, indicate that we should engage in a multi-method approach when it comes to evaluation assessment. And therefore, based on that adoption of those specialty guidelines, based on my work in the field of mental health since 2010, my work with inmates or justice-involved individuals since 2014 or 2015, it ensures me and it informs me that my opinion is not speculative.
Were your findings consistent with other peer-reviewed literature and established psychological principles?
My findings were consistent. Let me answer that in a different kind of way. The approach and the procedures that I used were consistent with any type of empirical research or examples, etc. My finding or my opinion is something that I reached based on using those methods that were consistent with all empirical research that's available.
Were the methods that you used, the forms that you used, were those reliable?
Yes, those tests and or forms, however you want to refer to it, have been used for years by psychologists across the nation.
Yes, but it has not started yet. We don't even have opening statements yet.
And you can learn about a lot of these tests. And these testing are well developed. In particular, the personality testing report was developed by Dr. Leslie Moore.
Let me turn off their sound just for a minute so I can explain this, because a lot of people are confused. We have not had opening statements yet. This is still a pretrial motion that was ruled on. The defense called this expert to testify about the mental capacity of the defendant due to voluntary intoxication. The judge ruled already that this will not be coming into the trial. But the defense, as they can do, motioned to say we'd like to have a proffer so we can put in the record what would have come in had you allowed it. This is just for the appeal.
The jurors walk by, everyone's done. One more question.
Would any reputable forensic psychologist say with absolute certainty that a subject had the requisite premeditation or requisite intent, or is that something that goes too far beyond an opinion?
Saying absolutely certain is going too far beyond an opinion. No reputable forensic psychologist or forensic psychiatrist should say anything with absolutism.
Thank you, Dr. Lewis.
All right, now the state gets...
So the jurors going?
Yes, Judge.
Jurors are going to lunch. We're going to continue.
Counsel protocol 2.
Counsel approach. We might go to lunch as well. I don't know. Can we continue through lunch? Who's the lady hiding behind the flag? And why is she hiding? Think of a judicial assistant. So this witness is using a term that is... I don't think widely adopted yet in the legal world.
Dr. Lewis, can you hear me?
Justice-involved individuals.
You might step off too.
That can be a witness. That can be a defendant.
Can you hear me now?
It can be a victim.
Yeah. Dr. Lewis, thank you so much. Mr. Watts will get in touch with you shortly to let you know how to proceed, how we're going to proceed in this case. I do thank you for your time this morning. Okay?
Absolutely. Thank you.
Yes, sir.
It's a privilege.
Let's go to lunch.
So the jurors just consent to lunch. They've got Jimmy John's in the jury room, which means it won't take them very long. So they'll give them a little time to walk around. So this will be our lunch break too. Are there any matters you want to take up before we take our lunch break?
Yes, Your Honor, two separate issues. One has to do with the indictment. The state has indicted Mr. Chen for abuse of corpse. In that indictment, we listed all of the factors under the abuse of corpse statute, two of which inarguably do not apply and would be prejudicial if they were read to the jury. One of those is disentering a corpse that has been buried or otherwise interred. The other is the other one is engaging in sexual contact. Neither of those are being argued by the state, so I would just request that I be able to leave those out when I read the indictment and only read the other two subsections that could apply in fairness to Mr. Chen. And then the other judge, so that the defense can object before opening statement, the state intends to introduce the suitcase that Ms. Pace's body was in during opening statement to avoid delay during opening statement where the jury has to go out. We figured we'd go ahead and disclose that now.
So you want to show the suitcase?
Yes, Your Honor.
I don't think they can do that yet.
Why is this common for evidence that's likely going to be admitted to be used in opening? Any objection?
Thank you, Judge.
Well, to the extent of all my past motions to suppress all those. So
You're not waiving anything.
Thank you.
Thank you, Judge.
All right, that clock says 12:20. Everyone will be back when that clock says 1:15. That's 55 minutes of lunch. What we're going to do is start the jury trial, bring the jury in. They'll be sworn. Instructions. Remain seated down. Remain seated. Still in session. You can leave, just be quiet. We're still in session. What will happen is the jury will be brought back in.
Everyone's running to lunch.
They'll be sworn. Or we did preliminary jury instructions to them, state the indictment, we're going to opening the first witness.
Yes, Your Honor. What time did you say? I apologize.
It'll be 1:15.
1:15. Thank you, Your Honor.
The court's in recess to 1:15.
There we go. Wow, so noisy in that courtroom. So noisy. So we're going to go to lunch. We're going to take a lunch. My daughter has made me fish sticks. She's just becoming a chef. She pulled those out of the freezer herself and cooked them out for me. Even got me the tartar sauce for them. So I'm excited. We have not even we haven't missed anything. This is how court goes sometimes. It's okay, all right. Apparently I've missed the South Park episode, so I'm missing the references. I'll take your word for it. Anyway, trial is just now going to begin. We were scheduled to begin this morning. The jury's been there the whole time. They are sequestered, which means they live here. They live at the hotel. They are from 2-3 hours away. They were picked in Nashville and transported to the courthouse here. They're going to stay here for the duration of the trial, barring they get excused for some misconduct or something, and through deliberations. And they're going to be sequestered, so they're away from the public. They won't have access to TV, news media, things like that, so they won't hear about the events other than what they see in the court. So that's going to be really interesting to watch, and I'd love it if the jury gets to ask questions. We'll see when the judge gives them the instructions here right after lunch. But they are sequestered to try to keep them from a lot of media coverage in this case. I'm not going to try this. Anyway, we're going to go to lunch. We're going to take a quick break. When we come back, we might come back a little bit early. We've got a couple things to show you. I might show you a little court case. Let's see. Let's see if I can. Not enough time to do everything we need to do. Let's see, where's that other one? John Slavens or Stevens. Is that still going on? Josh, do you know how long the hearing was for that that we watched a little bit on Friday? Amber, how long is the one from Friday? I'm asking you if you can tell me in chat or whatever. We only have an hour. If it's less than an hour, I might go to lunch. I might just save it. We start right now. We have time. Okay. Let's that'll keep us going. We have to have a break though. I know which one it is. I've got it pulled up. I just don't know how long it is, Amber and Josh. Sorry, they're talking to me in mod chat. This is a Tennessee case, 50 minutes now. We're gonna take a quick break. We might come back very quickly. I'm not sure if we're gonna have time to do this before the jury instructions, but we'll see. Trial's on Central Time. They only get an hour. He said 1:15. That's an hour. It's less than an hour, 50 minutes. This one's going to be over. We're going to come back with what is really part one of the trial. Everything here was pre-trial. And just give me a minute to get some lunch and build a new one. First person in chat, as always, will win the internet, so keep an eye for the little notification. Ring the bell. Click the subscribe button if you haven't. I would appreciate that. And we'll see you in a little bit. Tonight when you go home, please hug the people you love. Smile at someone. Make their day just a little bit better. And please stay safe. We go live again in about 40 minutes. 40 minutes. About 1 o'clock. Well, 30 minutes. 30 minutes is all we get. 30 minutes. We'll see you guys in a little bit. Have a good one.